Yeah, Lordship.
Yes.
Lordship, I beg to mention the number 22, 23, and 24. 22, 23, 24.
Why?
Lordship, in this matter, we are to file a substitution application. But substitution.
Let us see. Wait. Substitution petition. Earlier, did you made a prayer earlier?
Yes, Lordship.
Wait for some time. We'll see. Okay.
Okay, Lordship.
My lord, I beg to mention I unlisted my lord, for tomorrow.
This is
Listed tomorrow.
What is this matter about?
It's a succession matter, my lord.
Successor?
Yes, my lord.
No. Then in that case, you have to make a mention before the senior bench. Junior bench.
My lord, it was heard before this bench earlier, my lord. It was heard before this bench earlier. It has also been listed in court number 2 only, my lord.
So, no, still then, it has to be mentioned before the senior bench only, unless it is a bail or any other criminal. Make a mention before the senior bench.
Much obliged, my lord.
That's a rule. Okay.
Your Lordship, this is a civil revision petition against the impugned forwarding or the transfer of a matter related to land dispute between the private respondent number 3 and the petitioner by the village authority of Denka without conducting any trial to the apex customary court. Interestingly, in the name of the All Arunachal Pradesh Kampuri and Bura Welfare Association, which is, Your Lordship, not at all a designated customary court in accordance with the Arunachal Pradesh Civil Code 2021 and as well AFR 1945. This is basically a registered society and whose validation has got expired by the year 2019 also. Now no more exists. So, Your Lordship, the basic, the brief fact of the case is the private respondent number 3 had instituted a written complaint before the respondent number 2, who is a circle officer, and circle endorsed the matter to the village authority of the Denka. And at the first instance, the village authority of the Denka had served a notice to the petitioner seeking his attendance in the village authority proceedings. But to this, the petitioner had replied again with a submission citing all the facts and issues, and had also apprised the village authority that he had nothing to do with the disputed land and he hadn't sold any of the said land to any of the person. And lastly, he had also sought reasons for not appearing in the NIL because as he was suffering from cancer. Now, Your Lordship, this village authority of Denka, without conducting any trial, they had inadvertently and arbitrarily got it forwarded to the apex customary court in the name of Arunachal Pradesh Gambura Buri Welfare Association, which I have the veracity and the status of which I have submitted earlier. So, Your Lordship, while doing so, these village authority of Denka, they had underscored and violated norms. Number 1, with reference to section 5.1 of the AFR 1945, particular deputy commissioner appoints particular Gambura or police for a particular concerned villages to get settled, to matter get settled through amicably. But in this case, Your Lordship, this village authority of Denka, they have never conducted a trial. And secondly, Your Lordship, with reference to section 9 of the AFR Amendment 2023, if any of the parties aggrieved by the judgment or the decision of the village authority may appeal before, within 1 month, may appeal before the customary court or the inter-village territorial customary court. So, meaning apex customary court is basically an appellate court. So, Your Lordship, here, when there was no judgment, when there was no conduct of trial, the question of appeal doesn't arise. And thirdly, with reference to section 11, Your Lordship, if any one of the disputing party willfully remain absent consecutively for 3 times after giving not less than 30 days of time in each occasion of reasonable opportunity of being heard, then this village authority can go for, they can take or they can pronounce the ex parte decision. But in case the reasonable opportunity of being heard was not given to the petitioner,
No notice was issued.
no notice was issued. Only for the first time, one notice was issued. After that, the subsequent 2 notices should have been issued. That was also not done. And moreover, your lordship, with reference to the section 4,
So you were waiting for second and third notice.
second and third lordship, it is still pending. So your lordship, this honorable High Court,
Why
may-
you had to wait for second and third notice when you duly received the first notice?
your lordship, first notice,
If you
first notice,
if you have received the first notice,
page number 33.
yes, notice was given to you.
Yes.
Then
After that, I have been waiting. The matter is pending, and inadvertently they
my
have,
query, why you had to wait for the second and third notice when you received the first notice?
because your lordship, since I was suffering from
And then
cancer,
subsequently it appears that they have issued notice also. Second and third also it appears.
but it was not, your lordship, in the first instance, your lordship may see page 33, it was in the name of me only. And after in the second notice, there appears to be 2 persons.
Maybe, but your name were also there.
But your lordship, since I apprised the village authority that they are doing out of jurisdiction, and moreover, I was suffering from cancer.
Okay, have you agitated that you have no right and authority to decide a case? I cannot appear since you have no jurisdiction. Have you wrote that?
Your lordship, if at all, this village authority, they should have served me the second and third notice also. After that, only if possible, possibly they could have gone for ex parte decision also, but they could not send directly to, inadvertently send to the apex customary court, which doesn't exist at all. And that too in the name of all Gambura Buris Welfare Association. This is
Who issued notice to you? Gambura.
Gambura.
That was the first. This is not the apex body. It's Gambura only. GB of Denka.
Your lordship may come to page 37 and page 37. Your lordship may see it in the letterhead itself. It is all Arunachal Pradesh Gambura and Buri Welfare Association.
Page.
Page 37. Page 37. In the letterhead, your lordship may see Office of the Old Arunachal Pradesh Gambura and Bura Welfare Association. This is a registered society with its validation has got expired by the year 2019.
Yes, Steph. You were asked to obtain instruction.
Yes, Your Lordship. Instruction regarding the jurisdiction, Your Lordship. Jurisdiction, Your Lordship, Denka village and Bogoli village, they falls under same panchayat segment, Your Lordship.
They falls under.
Same panchayat segment, and head Gambura is also same, Your Lordship. They will be represented by the same head Gambura. That means by itself they are same village only, Your Lordship. That's why there is no issue of jurisdiction. Jurisdiction is good only, Your Lordship.
Who are the other parties?
Other parties, they are private parties, Your Lordship. They have, yes. They should be given a chance to be heard, Your Lordship. Notice should be issued.
Mr.
Arthai Bodia.
Typodia, counsel for the petitioner.
Lordship, the matter may be referred back to the original court of village authority. We are ready to,
Instance,
yes,
without giving notice.
so they should give notice and
There was no
This
notice
court may
issued, Your
direct
Lordship, in the
to complete
last
the-
occasion.
this court may,
There was no notice was issued in the last occasion, Your Lordship. Notice may be issued, Your Lordship.
Also heard Ms. Sangeeta. Nana government advocate for the state. You are representing respondent number 1, 2,
1 and 2, Your Lordship.
1 and 2. Stop. the petitioner filed this application under Article 227 of the Constitution of India, challenging the forwarding letter dated 12/5/2024 by the village authority of Tenka village, Gumto Circle, Papumpare district, to the apex customary court of Arunachal Pradesh in the name of, what is this AAPGB?
All Arunachal Pradesh
Gambura and
Gamburi Welfare Association,
Gamburi Welfare Association
a registered society.
for settlement of the complaint. It is submitted that the all Gambura and Gamburi Association welfare
Welfare
association
Association.
has no jurisdiction, no power and jurisdiction under, according to you, that they are not the village authority.
Not the village authority. They are a registered society.
Okay, so Gambura and Gamburi Association being a registered society, and therefore they have no power and authority under the Arunachal Pradesh Civil Court Act to decide the matter. Issue notice. Call for the record is necessary. Record is the first complaint was lodged before the CO.
CO.
So record is to be called from where?
Yes, Your Lordship. CO Gumto.
Okay. Call for the relevant record. Issue notice. The shall take steps upon. Sorry, since Ms. Sangeeta appear and accepted notice on behalf of the respondent number, state respondent number 1 and 2, no formal notice need be issued to the said respondents. However, the petitioner shall take steps upon the rest of the respondents by a registered post with AD, as well as by usual process within a week from today. Start. So they have already settled. Where is the impugn order? Settlement? Not yet settled or settled?
Not settled.
Not yet settled.
Not yet settled. It is
Then let
pending.
them come. Let them come. Okay. But then prima facie it appears that they doesn't have a power.
Yes,
They are-
Lordship.
Prima facie it appears that they doesn't have a power.
The apex court, Your Lordship.
Yes. So why they said they have sent whether the Gamburi, where you have lodged complaint, have they given any reason for sending this matter to the apex court? Apex customary court? Whether they have assigned any reason?
Yes, Your Lordship
What
may
is
come
the
to
reason?
page 36.
Yes.
They have assigned two reasons. The first one is both petitioner and the respondent are the relatives of the Gamburas and Buris of this Dinka village. But Your Lordship, in Arunachal Pradesh like this, the village having less populate, every third person is a relative of one another. And unless and until, yes, Your Lordship.
Okay. So with this reason that they cannot settle, they have sent forwarded to the Apex Customary Court. But in actual, they are not the Customary Court.
Otherwise, Your Lordship, there is a provision under which the GB can refer the case to the Apex Customary Court, Your Lordship. That
No.
is given in the
If they have not settled, whether they have settled,
Not
Yeah,
settled,
not
not
settled,
settled,
then
not
how
settled.
they can send without settling?
it is
Can send it back to CO that we cannot endorse it to somebody else.
Your Lordship.
Because initially the complaint was lodged before the CO only.
It's your Lordship.
So that.
Yes, Your Lordship. I think there was a settlement, Your Lordship.
Hmm?
In the same page, 36, page number 36, initial D, Your Lordship.
Yes.
In second paragraph, subsequently, mail was fixed on 11/5/2024 to attend a disputed land bogoli during the fixed mail dated 11/5/2024. Following persons were called as witnesses to examine the land, namely Shri Taing Rania Tar, GB Seriak, Shri Tanaram, Senior Citizen Bogli, Shri Tok Chandro, Senior Citizen Bogli, Shri Teshi Taya, Head Gangura Lekha Village, and Shri Tajan Kaur, original land owner.
In the
As
absence
for
of
the
petitioner,
pledger's witnesses, it is undisputed that present disputed land belongs to Shri Teli Tada. Therefore, Shri Tevia Kajum cannot sell the land to Shri Navang. There was a
This
decision. I think this decision has not been annexed.
Your Lordship, it seemed to be a predetermined judgment in the absence of petitioner.
No. You said that it was not, did not pass any order. This seems to be the case already has been decided, it appears.
But your Lordship, a village authority cannot pass at the
Where is the
Only-
order? Where is the order?
Only that order is not annexed.
Where is the order?
That's why.
This order.
Your Lordship, which order?
As
Order of
the
11/5/2024.
witnesses, it is undisputed that the present disputed land belongs to so and so. Therefore, Shri so and so cannot sell the land to Shri so and so. This amount to decision only.
So this is
So
predetermined.
on the basis of this only, probably they have sent it. Where is this decision?
But
Where
your
you have
Lordship-
not annexed?
But your Lordship, according to section 11 of,
Mail fixed on 11/5.
yes, it was.
11
Your Lordship, at this stage, notice may be
There is
issued.
no any such judgment. No judgment.
Later on, Your Lordship, this will come up.
It was directly forwarded to the FX Customary Court, and FX Customary Court, they had pronounced the impugned judgment.
Okay, what is this customary judgment about? 15 June 2024.
15 June. Customary, page number 41.
What is this about?
In the absence of the petitioner, the
Thane Council, you say that it was not settled. You are not challenging this order also?
I have challenged. Subsequently, I
Where?
have challenged. Basically, I am challenging the inadvertent act of the village authority of the Denka, and subsequently, I am challenging the impugned judgment passed by the Old Gandhara Buddhist Welfare Association. They cannot pass a judgment.
That is true, but then
Your Lordship, I think the 11/5/2024 has been annexed in this order, Your Lordship, in 15/6/2024.
When your Lordship may see page 41, the letterhead is Apex Customary Code, but here
there is a judgment also. Now, see,
a seal is imprinted on the name of Office of the Gambura Buri Welfare Association. And is it presided and signed by the president of the Old Gambura Buri Welfare Association, not the Apex Customary Code.
maybe, but that is judgment. You said that no judgment was passed. This was settled only.
Your Lordship, this was a
should be
judgment.
impugned order. Have you challenged this order?
This judgment was, your Lordship, not of the Denka village authority. This judgment was of the Apex Customary Court in the name of Arunachal Pradesh Gambura Buri Welfare Association, an impugned judgment,
Although, Your Lordship, the
which is a registered society.
may I, Your Lordship?
Hmm?
May I, Your Lordship?
Please.
Although the judgment has not been annexed, but the evidence is annexed in the annexure G only, Your Lordship.
No, this is judgment only.
This is judgment, but the mail record of the 11/5/2024 has been annexed here, Your Lordship. In
There
this
was no
judgment.
judgment regarding.
Your Lordship, make peruse 6, para 6, serial number 6. But due to constant threatening from Shri Devya Kojum, land seller, and Shri Navam Tagam, land buyer, the customary judges Simti Tajan Yaming, GB Denka, and Shri Tabayagam, GB Denka, has forwarded the case to Apex Customary Court on its for fair customary justice. Below, Your Lordship, it's written in the bold letter. Below, photo showing the mail record on 11/5/2024 at Bogoli. This photo, the following page, they have annexed the photo, Your Lordship.
Lordship, there was no judgment by the village authority of Denka.
Although judgment has not been annexed, Your Lordship, but
They have
the
served me a
photographs are
notice
there.
seeking my attendance on dated 11/5/2024. Now, I didn't appear, and despite that, they have forwarded it to the Apex Customary Court. I should have given the reasonable opportunity of being heard for at least remaining 2 times. So, Your Lordship, for the better interest of the justice, the matter may be referred back to the village authority of Denka.
Wait, Learned Counsel, we have to follow the procedure. Now you have to clarify why you have said that this no judgment. This is a judgment that by perusing the above fact and circumstance, it is crystal clear that the land being claimed by so and so is absolute title. That the land is so and so.
But Your
It's a
Lordship,
wrong judgment.
But Your Lordship, without giving me opportunity to heard or being heard for 3 times, if I remain absent also, then only they can get it, then it can be a matter of appeal or something like that.
You have to challenge the judgment. And without challenging the judgment, they have no power.
Your Lordship, in my understanding, when I feel that such
Rightly or wrongly, because
such
it was
association
forwarded
does not
and
exist
they
at
have
all.
no power, but then you have to say that it was decided and you are aggrieved. Yeah, customary judges have declared that so and so rightful title owner. It's a declaration of title, right title and ownership. See, this is just judgment. Have you challenged this?
By believing,
According to you, this is not judgment.
not a judgment. This Apex Customary Court in the name of Arunachal Pradesh Gam Buraburi, a registered society with whose validation got expired by 2019, it doesn't exist according to me. So it cannot pass a judgment. So and moreover, Your Lordship, with regard to section 40 and section
What do you mean by rightly or wrongly, they have passed this? First, accept that they have passed judgment, but they don't have a right.
They don't have it.
What do you mean by that? You don't agree with this? You don't agree with this, that this is a judgment. This is a judgment only, but then you have to challenge this. This should go automatically, of course, prima facie it appears. But then we have to admit that there was a judgment passed by this person, where they don't have a power. What is your submission? It's very difficult to understand. If you say this is not a judgment,
Yeah.
itself says the customary judgment.
May
Please
I-
see 41, page 41. Please see what it's written. Just read it. Page 41. Read the title.
Customary judgment.
Then what is this according to you?
But Your Lordship may come to page 37 also. When,
No, this judge, are you challenging? You have annexed, are you challenging?
yes, we are challenging.
See? Submit properly. When you challenge, when you have annexed some document, name the document. And when you challenge that document, name the challenge and then challenge that document, submit that you are challenging that. But then if you say undermining that, it's not a
Your
judgment,
Lordship, in the name of
then that
Apex,
will be difficult.
in the name of Apex Customary Court, it is being presided and signed
Page?
by the entity of
Page.
page 41. Your Lordship may come to page 47. 47. The end part of the judgment.
Yes,
This is,
henceforth,
the letterhead is Apex Customary Court,
maybe.
and
See,
the person who presided and signed,
that doesn't have a power, that will be decided. Apex Customary Court, but then it was passed in connection with the case between you and the respondent only. Therefore, it is a judgment in your case. This judgment, if they have no power and authority, it will go. But then first of all, you have to admit that this was a judgment passed pass in your case. This is declaration of right title and ownership of the land. Let us see your prayer.
Page 26.
Then before issuing notice, the petitioner also challenged the notice dated 16/5/2024 and 26/5/2024 issued by all Arunachal Pradesh Gambura and Gamburi Welfare Association. And the judgment, a customary court judgment dated 15/5/2024,
15/6.
15/6/2024. There is execution also, it appears, execution procedure.
Yes, Your Lordship.
See, it's coming one after another. Where is the execution? Any order passed in execution petition?
No, it has been forwarded by the extra assistant commissioner to the DLR also UPR. Your Lordship may come to page 51.
See, Lana Council, you have to be truthful in your mission. Page
Page 51. 51 to 76.
any order passed in the execution?
Not yet.
Hmm?
Not yet. Just initiated. Lordship may directly come to page 76.
The Lana for the petitioner, Father submits that the decree holder has already filed execution petition before the court of the deputy commissioner, UPR. And and the same has been forwarded to the district revenue and settlement officer district for execution. What is this? I'm directed to forward here to execution petition filed by so and so. Cancellation of LPC.
This daily Tadap is the petition, private respondent number 3. And Advocate Tanya Krupa is the legal counsel of the Welfare Association.
This is your case, and a counsel, you have to come prepared. And then you have to spell out the impugn order and your prayer. And therefore, praise for setting aside the impugn execution. You are praying for it, setting aside execution petition. Execution proceedings start. What is the case? Okay, start. Thereafter, it will come issue notice. Call for the record, issue notice, and steps. Thereafter, that will come. Yes, list is matter after 4 weeks.
Much obliged.
Obliged.
Just a minute. Okay.
My lord, this item matter may pass over for the time being, your lordship. The concerned counsel is on leg in item court number 1.
For the time being.
Yes, sir. Obliged. Sir.
First Lordship.
Yes.
Lordship, this is a civil revision against the ex-party decision passed by the Edgar Kaing, Western District.
Okay. Civil revision.
Lordship, here the Kaba was conducted in my absence. An ex-party decision has been passed against me, and I've
No notice was issued.
Lordship, not received any notice. I only came to know about the ex-party after the execution notice I've received.
Okay, where is the impugn order?
Lordship, it's page number 12. Page number 13 is the translated copy.
Page
Page
13.
number 13, 1-3.
You were directed to repay the amount with interest.
Yes.
Okay. So your presence was not recorded. No notice was issued.
Yes, Lordship, we have not received any notice. We only came to know after we got the notice of the execution.
You have undertaken to return the money within 6 months. Why you had to wait for decision of the court? Hmm?
Lordship, I could not pay back.
Huh? Yes.
Lordship, I didn't have the money to pay back.
So can it be justified? After taking loan, I didn't have money to
No,
pay.
my lord, I have just 2 grounds. One is that it is a time-barred claim. Since the loan was able in the year,
Time barred
yes,
and no notice. Have you
Yes.
filed appeal?
yes, Lordship,
Who
I
is the
filed.
appellate authority otherwise?
Lordship, it's inter-village
Hmm?
customary court.
Okay, have you filed
Lordship.
appeal?
Yes, Lordship, my appeal also has not been taken up on the verbal instruction of the EAC that since order has been passed in execution petition not to take up the appeal. That's why we have approached this court.
Execution petition also filed.
Yes, Lordship, we have filed an appeal, and appeal was not taken up on the verbal direction of the EAC that Since he has passed an order in the execution petition, the appeal should not be
Where is the
taken.
order passing execution petition? Okay, page 15.
Yes, Lordship, this is page 16 is the notice.
15 is notice. In execution.
Yes. Lordship, the order is in page number 18. The order passed in the execution petition.
He is right. The execution court, you did not file any appeal, and how can this, in the execution petition, in the execution proceeding, you have filed this application for setting aside ex parte, how the execution court came? He has no power. He's right.
Lordship, we have also sought for direction for retrial. Or else refer the matter-
Before whom you have filed?
Before
How
the
the execution court
executing
can
court.
give that kind of a direction? Execution court cannot change anything. Yes, he is right. But then thereafter, it appears you have filed an appeal before the village authority under so and so. What is this section 9?
Lordship, it's appeal provision.
You have the copy? Yeah, file. Regulation. So what about this? This is on 12th May. What happened to this appeal? Is pending or disposed?
Lordship, on the direction of the ESC, the village authorities, inter-village, they have not taken up my appeal.
So, but during the pendency of the appeal, unless it is disposed of, how can this court take up? There are only two appeal then.
Lordship, this is a civil revision.
This is revision,
Yes.
but the appeal is still pending against the judgment, against the order. Then how this revision can be taken up? Your appeal is pending disposal, not yet disposal.
Yes, Lordship, but the village authorities, they are not willing to take up my appeal. Since the ESC has stated that since execution is pending before her court.
Are
So
you
no-
challenging on that basis?
No, Lordship,
Then the appeal, because there is appeal provision
yes, Lordship.
from the judgment of the customary court. That you have to exhaust first. That is to be disposed of first.
Yes, Lordship.
Unless that is disposed of, how can you come before this court for revision when the appeal is still pending? There is appeal provision clear.
Lordship,
Since there is appeal provision, you have filed appeal before the appellate court.
yes, Lordship.
Then how can this case, this,
Lordship, they are not willing to take up this appeal.
are you challenging on this basis that they are not challenging? They are not, I have filed appeal, they are not taking up direct for taking up the matter.
Lordship, I've
That should
stated,
have been the
I've
challenge.
stated in my paragraph.
Where have you stated? Where have you
Lordship,
stated that
it's
you have
paragraph-
filed appeal?
Paragraph 4.
Is this current council? What is happening? Paragraph 1, 2, 3, 1, 2, 3 again. See page 3. See paragraph 1, 2. Page 4, paragraph 3. Then again paragraph 1. Then again paragraph 2. What is this? Which one? What is happening? Have you seen?
Yes, Lordship.
What is happening? Why this has to be done? So careless. Please be careful. Correct it. 1, 2, 3. 1, 2, 3 again. Which one? Which paragraph?
Lordship, page number 5. Paragraph 4.
Yes.
May I read, Lordship?
Darling council, this petition will be thrown away.
Lordship,
In somebody.
I may be allowed to withdraw and fresh a file.
That will be better. So confusing, huh? And then, since their appeal is pending, probably you have to challenge. The authority is not taking up. Your first prayer should be there only. Let your appeal be disposed of. Take up the matter. Appeal be disposed of as early as possible. That should be your prayer because it's already been decided. Or you withdraw the appeal and come for revision if they doesn't have a power. Because, or if they have decided ex parte in your absence or without giving you an opportunity. Okay, Mr. Yes, Mr. Mr.
Jika.
Okay, G. Kato, counsel for the petitioner wants to withdraw this civil revision petition with liberty to file afresh. This revision petition stands disposed of on withdrawal with liberty to file dismiss or on withdrawal with liberty to file afresh. Okay.
Obliged.
Yes,
May I please, Lordship?
yes.
Lordship, this is civil revision application. Challenging the infant judgment and order dated 5/5/2025 passed by the learned civil judge execution court in money execution number 21 of 2016. The petitioner before your Lordship is a decree holder and the respondent number 1 is the judgment debtor number 1. Respondent number 2 is judgment debtor number 2 and 3 is the JD number 3. Now, Lordship, may I take you to the execution application? Now, Lordship, before coming to infant order, the brief fact, there was a money suit filed by the present petitioner instituted against the 3 respondents. Accordingly, the said money suit number 35 of 2014 was disposed of by judgment and order dated 8/2016.
Please. Where are you?
Judgment and order phase 26.
26.
Yes, Lords.
Okay. Against 3 respondents.
Against 3 respondents, by judgment and order, the 3 respondents were made severally and jointly liable to repay the loan amount which they brought from the petitioner, Lordship.
Okay.
Now, thereafter, Lordship, even after the passing of judgment and decree in money suit, the respondent, they failed to repay the loan amount. Accordingly, Lordship, the execution petition was filed before the executing court, being numbered as execution case number 21 of 2016, under order 21, rule 42 of CPC, Lordship. Lordship, on filing of execution petition, the notice was issued to all the judgment debtors, 3 respondents, Lordship.
Okay.
Now, thereafter, direction was issued to all the respondents to file their affidavit of assets, disclosing their properties, assets, so that the petitioner, decree holder can realize their loan amount also.
Yes.
Now, thereafter, Lordship, accordingly, the affidavit of assets was filed by 3 judgment debtors, but by order dated 25/5/2022.
No, all the 3 respondents.
Yes.
Judgment debtor has filed their affidavit in.
Yes, affidavit of assets. Yes, by
All the
disclosing
3.
all 3. Initially, they have filed. All 3 have filed.
Okay.
Now, thereafter, Lordship, may I take you to the order 25/5/22, annexes page 78, Lordship. 78.
7-8.
78, Lordship.
Yes.
May I read? Applicant DH, decree holder is represented by learned so and so. JD number was is represented by learned counsel so and so. JD2 is represented, and JD3 is represented by so and so. On perusal of the case record, it appears that the present execution petition is pending for attestment of the movable and immovable properties of the JDs and for sale of the same to recover the decretal amount. Since all the JDs have filed their affidavit of assets in the year 2017, but on perusal of the same, it is found that the same has not been filed as provided under form number 16A of Appendix E of the CPC. Means their affidavit is not accordingly as per these provisions, not in formatted manner, Lordship. Accordingly, Lordship, furthermore, boundary of the immovable property is not properly mentioned in the affidavit filed by the JDs. For the aforesaid reason, writ of attestment could not be issued. Accordingly, all the JDs are directed to file fresh affidavit of their assets and properties as per aforesaid form. Means earlier their affidavit, it was not as per format. Accordingly, direction was given to file a fresh under this form. Now, thereafter, Lordship, by order 21, may I take you, Lordship, to page number 79 onwards. Page 79.
Yes. It's 28.
Yes. Learned counsel so and so, so and so. JD number 3 is presented by so and so, so and so. JD3 is suffering from ill health, therefore another date may be given to him to comply with the order. The learned counsel for DH has prayed that since JD1 and 2 have not complied with the last order of this court to file affidavit of their assets and properties, so order may be issued by this court directing JD1 and 2 to be detained in civil imprisonment. Upon hearing and perusal of the record, it is seen that JD1 and 2 were represented on the last date, and the court has directed all JDs to file fresh affidavit of their assets and properties as per the prescribed form number 16A of Appendix E of CPC. But JD1 and 2 are absent and has disobeyed the order of this court, and therefore, as per order 21, rule 43(3) CPC, this court is inclined to issue arrest against both JD1 and 2. Issue civil warrant of arrest against JD1 and 2, so and so. Now then, next page, Lordship, 81. May I read from the
Yes.
fourth para?
Yes.
Operative. JD1, so and so is produced upon arrest, and learned counsel for the JD1 has
They
submitted
were
the-
arrested also.
arrested. He is ready to comply with the direction of this honorable court to furnish affidavit as per order 21 rule 41 CPC. Therefore, JD1 may be released and not detained in civil prison. Accordingly, he was released on statement that he will file the formatted affidavit, Lordship.
Okay.
Now, Lordship, the next page 82. Counsel for DS has submitted so and so, so and so, so and so. Directed to JD1 is directed to file today itself the affidavit of assets as per so and so, form number 16A. Heard the learned counsels, accordingly, JD1 is allowed to be released due to so and so. Thereafter, Lordship, 83. Page 83.
Yeah.
May I read from fourth para?
Yes.
JD2 has filed affidavit of assets today.
Fine.
Means JD2 already filed, Lordship.
Hmm.
Then, Lordship, page 84.
Hmm. Yeah.
84. Then 84. DH is represented by counsel. JD1 is represented by counsel. So and so is presented by so and so. 3 is presented. The learned counsel for DH has submitted that she has gone through the affidavit of asset filed by JD and that most of the properties declared in the affidavits are located outside the jurisdiction of this court and wait for time for making necessary submission and for filing of necessary application in this connection. In fact, till date, JD1 not filed. Now, phase number
Till
80
date, JD1.
not filed.
Okay. And what about 2?
2 and 3, they have already filed in formatted manner under Appendix E,
Okay.
16B. That is, their affidavit has also been annexed as 9 series
Okay.
is the affidavit of JD2, Lordship. And then, Lordship, page 94 is the formatted affidavit filed by the JD number 3.
Okay.
Now, Lordship, thereafter, may I take you to the order 21/3/2023, 113, page number
Yes.
103.
Hmm.
Last, may I read the last para, Lordship?
Yes.
113.
Hmm.
Third, JD1 is directed to once again to file the affidavit disclosing details of his property, house located at Polo Colony, Naharlagan on next day without fail in order to enable this court to issue order of attachment. Means till 21/2023, the JD1, he failed to file his affidavit of assets despite the various directions issued by the executing court. Now, Lordship, then next 114. May I read after counsel, Lordship. In the documents submitted as affidavit of assets filed by the JD1 through his counsel, so and so, it is seen that there is no swearing before Seristedar. By this order, it shows that they have filed their affidavit, but it was not shown before the Seristedar, Lordship. Accordingly, the learned counsel for JD1 is once again directed to file the affidavit of assets of JD number 1. Again, fresh direction was issued, Lordship, on 7/8/2023. Now, Lordship, 115 again. I am showing all this because order itself reflects that JD1 has not yet filed his affidavit, Lordship. But despite of that, my execution application was dismissed. Now, second last para, Lordship. The learned counsel DSA submitted that more than a year's time has been taken by JD1 to file affidavit of assets, and JD1 is deliberately delaying the execution case, and therefore show cause notice may be issued prior to issuance of civil warrant of arrest. Till the order of 10/10/23, he failed to file. Accordingly, the counsel for the decree holder filed for issuance of show cause notice before issuance of civil warrant, Lordship. Accordingly, thereafter, warrant of arrest was issued against all the 3 JDs. But JD number 3, they filed a CRP before this honorable court, challenging that warrant of civil warrant of arrest, and accordingly it was quashed. Lordship, the High Court order I have also enclosed at page 118, and the operative person is 120, Lordship, page number 120.
Exceeded jurisdiction.
Yes, that civil warrant was quashed by this honorable court. para 5 and 6. Small para, may I read, Lordship?
Yeah.
In the given fact on the present case, more particularly where the judgment debtor is participating in the proceeding before the executing court, declared the forfeiture, but that can be attached for execution. There is no necessary for passing the impugn orders. In as much as condition precedent is required to put a person in civil prison for execution of decree was also not available and or discernible from record. Para 6. In view of the aforesaid, this court is of the view that the learned executing court has not only exceeded its jurisdiction, but also failed to exercise its jurisdiction while passing the impugn order, that is 7/6/24. This is the order where the civil warrant of arrest was issued against all three JDs. And therefore, aforesaid impugn order, so far the same relates to issuance of civil warrant of arrest against the judgment debtors is then quashed. The learned executing court accordingly shall continue to proceed with the execution proceeding as per law. Now, that civil warrant was quashed, and at the same time, direction was issued to the executing court to proceed with the execution process, Lordship. Now then, Lordship, next page 121. Decree holder is presented by counsel so and so. JD are absent. Learned counsel for JD. The learned counsel for the decree holder has filed daily petition number so and so and annex CTC of the order passed by the Honorable High Court. By this order, we have already the counsel for the DH. They furnished the CTC of the Honorable Court order before the learned executing court. High Court, Itanagar Permanent Bench on 23/10/24, wherein civil warrant of arrest was issued against JD number 3 was quashed. Had seen the order of the Honorable Guwahati High Court, Itanagar Permanent Bench, seen that instant execution case is pending before this court for more than 9 years, Lordship. This is the observation just after quashing of the warrant by the High Court. This is when matter was put before the executing court. And decree holder, learned counsel for DH has failed to locate the property of JD. Now they are alleging on the decree holder who is failing to locate the properties. How the properties of JD can be located when the JD was not filed the affidavit of SS, Lordship. I have seen the previous order. Hence, last opportunity is given to decree holder to locate the properties of JD within jurisdiction of this court and file necessary application. This is the second last order before passing of impugn order. Now again, Lordship, matter was fixed on 5/5/25. Now, on dated 5/5/25, one matter was listed up, taken up before the learned executing court. May I take you to the impugn order, Lordship, page 25. Annexure number 1, page 25. At the very beginning. By this impugn order, they dismissed my execution application. May I read, Lordship?
Yes.
Decree holder is presented by learned counsel so and so. JDs are absent. Learned counsel for JD is absent. Learned counsel for decree holder has failed to locate any property of JD within jurisdiction of this court. Further, it is seen that instant money execution case is pending before this court since 2016, and no property of any of the JDs have been located till that within the jurisdiction of this court. Further, it is seen that address of JD number 2, Doluyate, and JD number 3, Gadamate, is in Wetcham district. It is also noted by this court that limitation period to file now the learned executing court, they started raising the jurisdiction, Lordship. That too, how illegally they found, Lordship. May I read? It is also noted by this court that limitation period to file execution case as for Article 136 of the Limitation Act is 12 years from the date of decree. Where the question of limitation arises, Lordship. Since the execution petition was already pending before the executing court.
No,
Then next, accordingly, instant money execution case is dismissed for default with liberty to file fresh. What is the default? On the very date that the counsel for the decree holder was represented.
okay. Yes.
On location of one, on 2 counts, the said execution application was dismissed, Lordship. First, on location of property of JD number 1 within the jurisdiction of this court, if any, or they are directing me to where I should file the execution application, Lordship. Dismiss for default with liberty to file afresh. First, on location of property of JD number 1 within the jurisdiction of this court, if any, in the concerned court where property of JD 2 and 3 are located, provided the same is filed within the limitation period, Lordship. Registry is directed to duly keep the record in the record room.
So, you have met party to whom?
All the 3 JDs, Lordship.
Okay. Issue notice.
Notice and Lordship, this impugn order is reserved to be stayed. All for the records, Lordship.
Mr. Kiloli. Non-counsel for the petitioner. For the issue notice. It is submitted that, sorry, by filing this application under section 115, read with section 152(1) of the Code of Civil Procedure 1908. The petitioner has assailed the order dated 5/5/2025 passed by the Learned Civil Judge, Senior Division, UPA, in execution, case number 21/2016, by which the execution petition, the execution case has been dismissed for default with liberty to file a fresh. Stop. It is submitted that the execution case was pending for some filing of affidavit of assent by the judgment debtor. And on 5/5/2025, the petitioner was present. This 5/5 was fixed for what?
Lordship,
On 5/5/25,
yes,
it was fixed for what?
fixed with a direction to the decree holder to locate the properties of the
Okay,
judgment.
now the decree holder is to locate the property.
Properties of the judgment debtors.
Hmm.
But that too before filing affidavit by judgment debtor number 1. Instead of directing the judgment debtor number 1 to file affidavit in terms of earlier order, they alleging that the decree holder failed to locate the properties of the JD. How this is possible also?
However, instead of but the respondent judgment debtor remained absent. Stop. However, instead of directing the judgment debtor to file affidavit of assent, the Learned court has dismissed the execution petition for default. With liberty to file afresh on location of property of JD number 1, judgment debtor, within the jurisdiction of this court, within the jurisdiction of this court, and in the concerned court, the property of judgment debtor number 2 and judgment debtor number 3 are located. Stop. This, according to the learned counsel for the petitioner, is contrary to the law. And the arbitrary and contrary to the law. Stop up there. List this matter. Have I directed to take steps? Okay, we take steps within a week from today. After issue notice, the petitioner shall take the respondents by a registered post with AD within 7 days from today. Stop. List this matter after 4 weeks. Stop. In the meantime, the operation of the just a minute. In the meantime, the order dated 5/5/2025 passed by the 5/5/2025 passed by the learned civil judge, senior division, in number 21/2016 shall remain state till the disposal of this petition. Staff. So now let them appear. Thereafter, it will have to for restoration. It will be directed. I think.
Yes. Yes.
Okay. List is matter after 4 weeks.
Record call कर दिया. Record call कर. Deeply obliged.
Lordship. Lordship, here applicant is seeking pre-arrest bail. So this is a very old matter, 2019. During that time, I was declared as proclaimed offender. Now this matter has been charge sheeted. Charge sheet, Lordship will find at page 13.
Yes.
In the year 2020. So my Lordship, at this, now my limited prayer would be, Lordship, that let me stand trial. I will stand trial. Moreover, I'm.
What is this? That it appears that you participated in the trial.
No.
That is different case, Lordship.
Hmm?
That is different PS case,
Yes,
Lordship.
this is.
That
I'm. There's one more pending case against me where I'm standing trial. That is that.
Why you have annexed this?
Yes.
Order 44.
Yes. This is that. This is in that matter at Khonsa. This PS case is different. The matter is different. Khonsa PS, NDPS case number 44 of 2021 in Khonsa PS case 14 of 2018.
The present case is.
Present case is of NDPS Special Court NDPS UPR.
Okay, this is.
Yes.
But why you have annexed this order?
It's to show that if I'm protected, I stand trial because I haven't violated any terms and condition of bail in that case also. There I am standing trial. Here I have not received anything.
Since 2019, you have never appeared before the
Yes,
police
because
or before the.
yes.
Have you filed bail application earlier?
No.
Come to page 5. Para 7 last.
Last. Yes,
What did you have?
that
stated?
pertinent to
In the
mention here
aforesaid
in,
case, the applicant is facing trial regularly until now.
yes. It is in for the Khonsa court, Khonsa NDPS court. I'm standing trial there.
Okay, you have been granted bail.
Yes, yeah, from
in
there
some
I
other
have
case.
granted bail. In that case, this way. I'm mentioning this to show that the applicant is facing trial at the court of NDPS Khonsa. That's why he will face trial at NDPS court in UP also. Before you NDPS.
It appears that you have never appeared on
Yes, Lordship, that's what I was.
proclamation offender. You have been declared as a proclaimed offender.
Yes, from doing
On many
investigation.
occasion or what?
That is annexure 1.
Warrant issued in how many occasion? Issued on how many occasions?
Lordship,
Warrant
that's why I have never received warrant actually. Only my counsel.
Non-available warrant issued on 1, 2, 3, 4, 5, 6.
Yes, 6.
As
Okay.
much as 6 times.
Yes, but I haven't received. And also without going to the merit, because how proclamation was declared also, that is also doubtful. So
NDPS
yes,
booked under what section?
22B.
22B.
Yes, intermediate.
Oh, difficult.
Lordship, now
Charge sheet also filed against you.
yes, charge sheet also
But then
filed.
you were not examined.
No,
How-
that's why Lordship, what my humble prayer before this honorable court is that if I am protected, I will appear before the special judge NDPS UPI and they may start trial against me.
You surrender before the special judge then.
Lordship,
The
since
special judge
I
of
have been
Parliament,
declared locum offender, so there will be no provision of surrender.
That is why you have to surrender before that court and then make a prayer for bail.
Lordship, that's why I'm before this honorable court that if I'm protected, I will appear there. But till now I need protection so that I can appear there.
Yes,
Lordship, why the applicant took so long time to appear before the court, Lordship? Because as per the Lordship, section 82 of CRPC, the proclamation, Lordship, when it is issued, because they failed to appear before the court. And as per this section 82, Lordship, after receipt of the notice, Lordship, he should appear before the court within 30 days. But he failed to do so. And order passed in 2019 and now is 2025. So, Lordship, it's better to surrender and Lordship may apply for the bail, the concern below court below, Lordship, in the appropriate court, Lordship, that is, Lordship, a special court. We can seek the bail in that court also, Lordship.
Lordship, 2019, that was during investigation. When proclaim is
see, there are the
Lordship.
subsequently on 2020.
when proclaim is declared, how and how when they say that I am absconding. Now, Lordship, now charge sheet has been filed. I am here before this honorable court so that the state, they don't want my custody actually, they want only trial. So I will stand trial before in the NDPS court. I may be protected, I will stand there because I am already appearing in another case. So it is not possible that I won't appear in this case also. And looking at and that's why I'm saying that Lordship, without going
The
into
other
the merit
case-
that how, why, where proclaim has been declared, give me protection, I will appear before the NDPS court, Lordship. Only then.
Lordship, it's better for him to surrender before the court and seek bail, Lordship, before that.
Lordship, if
session,
trial starts,
Lordship,
obviously I have to file bail there. Bail matter will be decided on
the
that
next date
merit.
is- When the next date is fixed?
That's why, Lordship, there's no order, except only to the 19
It-
order they have annexed, Lordship. Now, in what stage, what's going on, we also don't know.
Yes, that is why, Lordship, if I am protected, I will go there. Within 30 days from today, I will appear before the NDPS court UPR. I will file their bail application. And
Lordship, when, Lordship, it is,
Till
Lordship,
then I-
already they have violated the terms condition, Lordship. before this court in the anticipatory bail, how it is possible, Lordship, where it is already proclamation was declared against that accused. So, Lordship, when he not comply with the order, Lordship, that is 2019, Lordship, till date, now he is coming for the anticipatory bail.
Lordship, we have to understand one thing, why proclamation? Because I am never arrested for
Because he was
prosecution.
absconding, Lordship, that's why he was
That's
never
why
arrested.
proclamation is issued. That's
Yes,
why I
Lordship.
am saying that since they could not arrest me, they could not.
Arrest with that means, Lordship, that
So
he
where is-
wants
where
to
is-
get the
just-
anticipatory
just-
bail just now, Lordship.
Have you annexed this last order 10/4/2025?
No, Lordship, that I have not annexed here, Lordship, because Lordship here only limited prayer is that, Lordship, if I am protected, I will appear before NDPS court within 30 days and I will file bail application therefore, and that will be decided on the merit of the case there, Lordship. Till then, so that I can appear before NDPS court, I should be protected, Lordship.
That means no need to call for the record also.
Lordship, by simple direction, if protected, I will go there. And NDPS court, a special judge may decide my bail application there on the merit there, Lordship.
Heard Mr. Kumble, Learning Counsel for the petitioner. I've also heard Mr. El Hakim, learned additional PP for the state staff. This is an application filed under section 482 of the BNSS 2023, praying for granting pre-arrest bail, apprehending his arrest in connection with NDPS case number 03/2020 in ETA-PS case number 127/2016 under section 22B NDPS Act read with 27 also. That's what 25 IA.
Yes, Lordship.
25
Arms Act,
IA.
Lordship.
Arms Act. That comes difficult. You actually don't deserve. The case of the petitioner is that ETA-PS case number 127/2016 was instituted on the basis of written FIR received from one three SI K Parting on 4/5/2016 at about 1630 hours, stating that has secret information received from a reliable source that his name is Kampai,
Compile, Lordship.
once the Kampai Wangsu, accused, within bracket accused applicant, staying at AIR colony, C sector, is in possession of brown sugar and selling it to customer staff. On receiving such information, under such information, under the supervision of subdivisional police officer Itanagar, they made a raid in quarter number 5W16H, where the accused resides. Stop. During raid, the accused managed to escape from the back door. Stop. However, on query, his daughter revealed that her accused father kept the brown sugar in a box, and when opened by her, a packet containing brown sugar, approximately 3.5 grams, comma, case amount of rupees 15,700, comma, 10 numbers of live 0.32 grams, 0.32 ammunitions, comma, 1.32 empty pistol magazine, and one dagger were found, which were videographed and seized in presence of independent witnesses and under supervision of SDPO Itanagar. Based on the above, a case was registered under Section 22B NDPS Act 1985, read with Section 25, 1A of Arms Act. Upon completion of investigation, the IO has submitted charge sheet against the accused under Section 22A NDPS Act read with 25 1A Arms Act. Stop. The land counsel for the petitioner submitted. He has never received the submitted. He has never received any summons or warrant from the police or the court. However, he has collected an information that a non-bailable warrant of arrest were issued. Non-bailable warrant of arrest orders were passed on 23/7/2019, 18/8/2022, 23/7/2024, 24/10/2024, 28/11/2024, and 10/4/2025 by the Special Judge NDPS UPR. However, the accused applicant had no knowledge about the aforesaid orders. He only came to know when the cause list of the Special Judge NDPS UPR were uploaded in WhatsApp. And the same was informed by the advocates, by his counsel staff. The land counsel for the petitioner further submitted. He is also facing trial in another similar case at Konsa, where he was granted bail. Where he was granted bail, and And till now have not violated any terms and condition, any terms and condition of the bail granted to him. Start. The learned, however, at this stage, the learned counsel for the petitioner has a limited prayer that since he had no knowledge about the issuance of several non-valuable warrant of arrest against him, now he is ready to surrender before the trial court. And till then, he should be protected by interim anti-security bail. Start. So
Lordship, then when is the next date, Lordship? Because 2019 order we have annexed here, Lordship.
he will surrender himself before the special judge within 30 days. What he
From,
says.
yes.
Lordship. Then Lordship, interim should be Lordship till that time only, Lordship. Then it may be automatically cancelled after 30 days because as per his,
He will file the bail application.
yes, Lordship, he
And till the
should,
disposal, he will be protected.
yes, Lordship. Then he will be filed till 30 days, Lordship. Till then.
Miss, okay. Again, none additional people for the state, some state. Even if the interim protection is granted to the applicant, he should be there, he should be clearly directed to appear before the learned special judge within a specific date. A specific period, stop. In view of the above, in view of the above, and as agreed upon by the learned counsel for the parties, the accused applicant is directed to accused applicant is directed to surrender before the learned court of special judge NDPS UPR within 30 days from today. So, and 30 days from today, and seek regular bail from the state court till such period. Till then, it is provided that the accused shall till such period, it is provided that the accused shall not be arrested. Okay. Not be arrested. No coercive measures be taken against the accused. And surrender within 30 days and file a regular bail before the state court. Okay, till such period, it is provided that the accused no coercive action shall be taken against the accused. Okay, till disposal.
Yes.
Okay. Yeah.
Lordship, then Lordship, the next step may be again fixed, Lordship. Only interim protection may be given, Lordship. This is come under AB, Lordship. Interim, in the meantime, if they surrender before the court and regular bail, if they approach their Lordship, then it may this AB may be closed, Lordship.
Okay. So
So
on
then we can
surrender-
also ascertain whether he has surrendered there or not, Lordship.
Okay. No, then because he will be filing regular bail.
That's why, Lordship.
Okay, then 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 that will be interim. they leave the interim part. And in the interim, it is provided that in the event of the accused being arrested during the period, he shall be released on interim anticipatory bail on execution of bail bond of rupees 50,000 with one surety of like amount to the satisfaction of the
Special court laws. Oh,
the special judge NDPS UPR with the further condition that he shall cooperate and appear before the trial court regularly, and that he shall not regularly.
No, Lordship, condition should be that he should appear before the Lordship, special court, within 30 days, Lordship.
No, that we have recorded.
Yes, well,
He will surrender before the, okay.
Yes.
yes, Lordship.
So I'll correct the order, okay. So this, what he will do, he will surrender within 30 days.
Yes. 30 days.
Okay,
Yeah.
and during these 30 days, if you are being arrested, release on interim anticipatory bail.
Yes.
And then after surrender or after, during this, you will file regular bail before the
Yes.
trial court.
Trial court, yes.
And until disposal of that trial court bail,
Yes.
because this, I'm giving you interim protection. So till regularization or the court will dispose of the bail on in its own merit.
Yes. Lord.
Okay,
That will be their own merit, Lordship. That this interim should be till 30th of, 30
Yes.
days, Lordship. That is my.
okay, that I'll clarify. Okay.
Yes.
You are within for 30 days, you are interim, you
Yes,
are
Lord, sir.
protected by interim order. Within this, you have to surrender and then
Yes.
file bail application, regular bail
Yes.
application. And then that bail application will be disposed of by the
Their own
trial
merit.
court
Lord,
on
yes,
its own merit.
Yes,
Yes.
Lord.
Lord.
Okay.
Yes.
That will do. Okay. Okay.
Hi.
Then
Therefore,
list again,
bail
Lordship,
application
again,
steps.
Lordship.
Hmm?
This matter should be list again, Lordship, because Lordship, in the meantime, this.
No,
on
this
interim.
disposable is in
Only-
that direction.
Okay, Lord.
Yes.
Okay, disposal.
Hi, Lord.
Yes. Madam, this is a criminal petition, praying for setting aside and quashing of the FIR dated 4/2013, leading to registration of Passikat PS case number 12 of 2013 under section 332 of IPC. My lord, out of on 4/2013, out of motor collision accident, 2 FIR was lost by the number 3 and petitioner. My lord, can you see at page number 11? Is the insurance affairment. Only 2 sentence affairment.
Yes.
Page number 11.
Okay, the other side also. Okay.
And but other side in page number 13.
Okay.
Page number
So,
13.
so we'll issue notice
Yes, madam.
at the moment. What is the status of the case otherwise?
Well, more than 12 years has been passed.
Hmm?
More than 12 years has been passed. The police
12, more than 12?
12 years has been
Okay,
passed.
no, the case, status of the case before the court.
No charge sheet was filed.
No charge sheet,
Yes.
probably,
I'm not aware of the fact, Your
okay,
Lordship.
probably limitation of that.
Yes, if the record is called from, CD is
Okay, we'll
called
call,
from.
we'll call for. Okay, Mr. O Modi, Learned Counsel for the petitioner. This is an application filed under section 528 of BNSS 2023, praying for setting aside and quashing of FIR dated 4/2/2013. Leading to the leading to the registration of PS case number done, setting aside and quashing of the FIR dated 4/2/2013, leading to the registration of PS case PSG Passikat PS case number 12/2023 2013
Yes.
under section 332 of IPC. Whether the other counter complaint was Counter FIR was registered.
No, my lord. That FIR was started.
Okay, stop. Call for the. That will be then, if
Case
you don't know,
diary,
if you say that charge sheet not yet filed, it will be case diary only.
Case diary, your lordship.
Case diary. It will be scanned.
We can seek for the scan copy.
Call for the scanned copy of the case diary. Issue notice. Since Ms. Jenny has accepted notice on behalf of the state respondent, no formal notice need be issued to the respondent number 1 and 2. Stop. The petitioner shall take steps upon the respondent number 3 by a registered post with heading within 5 days from today. List this matter.
On
After?
16th, your lordship, on
List this matter
16th,
again on 16. Okay.
deeply.
Yes.
Your Lordship, this is a criminal petition filed state represented by the OCWPS Itanagar on being highly aggrieved by the order dated 15 March 2025, Your Honor. So we have challenged the order dated 15 March 2025. And as per the order dated 15 March 2025, Your Honor, victim B, who was already examined, was recalled for the re-examination. Your Lordship, brief prosecution case. I will begin with the FIR, Your Lordship. Your Lordship, this FIR was filed on dated
Who
4
appeared for the state here?
Your Honor, Your Lordship, I'm representing the state as an
Okay.
SPP, and PP is also here.
You're for the state.
I
Yes.
thought you said, my lord, it has been filed through the IO. She's representing the IO of this case.
Through IU.
Yes, your lord.
OCWPS.
Okay.
The criminal petition from the end of
Right.
from the state end, your lord.
Okay. So when the next date is fixed?
2nd August, this coming August.
2nd August.
Yes,
Whether someone has already been issued?
yes, someone has already been issued, Your Lordship, and the victim was present on 31 May, this May. But however, she was not examined on that date,
Not examined.
not examined.
Then she need to be examined. That year.
No, no, Your Lordship,
Okay.
may I?
No, whether earlier.
Earlier, she was already examined, Your Lordship.
Okay, then.
And she was also cross-examined by the respondent.
Okay, she appeared twice. Was examined earlier
She was examined earlier.
by the prosecution side.
Yes, and she
She
was
was cross-examined on the next date.
no, she, on the same day, she was cross-examined by the this one,
Defendant.
defense counsel,
Okay.
particularly by this
Defense
respondent.
counsel. Yes.
And after her cross-examination, her evidence was closed and she was discharged
Okay.
as a PW2, Your
Hmm.
Lordship. But however, on the application filed by the respondent, this present respondent,
Hmm.
Your Lordship,
Accused.
yes, the accused,
Hmm.
the victim was again recalled for re-examination under
On what point?
Your Lordship may kindly see. Page,
Whether police personnel had threatened the
yes,
victim.
only to put this question, only for the purpose
This-
of,
So this was not asked.
Your Lordship may kindly see the page number 46. This is the deposition of the victim.
This is the Okay, victim
Page
C.
number 46, Your Lordship, page number 46.
yes.
Cross-examination for accused Senator Ronia, the present respondent,
Okay, already cross-examined.
already cross-examined.
Then
Your Lordship may see that it is a fact that while giving statement before magistrate, I have not stated the name of the accused Senator Ronia to be an assailant. It is not a fact that I have stated the name of accused Senator Ronia while recording of the statement by police. Photograph of accused Senator Ronia was not shown to me at the police station. I cannot remember as to when and where accused Senator Ronia has committed sexual assault upon me.
It is not a fact that as many person had did galat come with me for which I have wrongly identified the accused person. Presently, I am staying at CCI Oju Mission and no police personnel came to meet me there. So, Your Lordship,
Okay, then what more we want?
exactly, Your Lordship, because regarding the police personnel, the questions was already put. She has very categorically, maybe in the implied manner, Your Lordship, this section, recalling of the witness cannot be used to fill up the lacuna. In this case, they are trying to fill up the lacuna by the defense counsel, Your Lordship. On the same question which has already been,
Time and again, a secondary victimization of that.
yes,
That would be difficult. Anyway, what we'll do, we'll issue notice.
Your Lordship, I'm praying for the stay of the order dated,
Naturally, that
yes, Your Lordship.
it appears. Prima facie it appears.
And Your Lordship, it's my humble prayer, since there are many petitions after this petition was allowed, there are many more petitions pending before the special court regarding the recalling of this, they want to examine. So, stay on this order and get clear instruction until the disposable of this petition, no
Yes.
victim shall be re-examined.
Okay, hard. Miss Peter. So,
15
Sorry.
March 2025.
who is appearing theater?
I'm for the stay, my lord, and
Even-
she's representing the OC as a special PP boxer.
So she will represent that Ms. K. Babu. No?
Yes.
Non-counsel for the. You are a special PP.
Yes.
Non-special PP.
Boxer.
So. Case, huh? This is an application filed under section 528, railroad section 438 and 442 of the BNSS 2023. Start. Challenging. The order dated 15/3/2025 passed by the Learned Special Judge POCSO Act, Ethiopia, in POCSO case number 08/2024, whereby the victim number B within bracket W2, PW-2 bracket close, has been recalled for re-examination. Fact. It is submitted as the victim within bracket, or victim B
B.
within bracket PW2 has already been examined in connection with POCSO case number. In case POCSO case number 08/24, in NDPS case number 2024. When it was examined?
13th December
On
2024.
13 December 2024. And thereafter?
Thereafter, Your Honor, on the same day, she was cross-examined
Okay,
also.
and she was, on the same day, she was cross-examined and discharged. Stop, huh? So,
And on the basis of application filed by the respondent, miscellaneous, criminal miscellaneous application.
thereafter, the accused, is accused number? Accused number assigned?
No, Your Lordship.
Okay, well, thereafter,
Present, Respondent.
the accused, the respondent,
He's the only respondent because he's
okay, respondent file an application,
criminal, annexure 10,
annexes and page,
page 49.
file criminal miss application 68 of 2025 under section 348 of BNSS 2023, praying for recalling and re-examination of the victim BPW2
Only to put question whether police and that page number 50 paragraph.
The ground for making such application is that the other victims have stated that they were threatened to give against the accused, give evidence against the accused person, and falsely identify them to make out false case against the accused persons. Therefore, prays that the accused, sorry, the victim B, PW2, be recalled only on the to put question within inverted comma whether police personnel had threatened you to falsely identify accused Senior Ronia and to give statement against him. Question mark and inverted comma close. Stop.
And on and this application was heard on 15/3/2025.
The said application was, where is the include? The said application was heard where is the operative portion of the
Your Lordship, page number 22. Page number 22.
Yes.
Para 14, it is ordered that victim BPW2 be recalled for her examination for determining the
Heard and allowed. Heard and allowed. And directed and ordered that the victim BPW2 be recalled for her examination for determining the limited questions as mentioned in criminal case number 68 2025. Stop. It is submitted that if since the victim witness number 2 PW2 then what is her age? What is her age? Victim.
As per her own verbal statement, she as per ossification test, she's only 12.
Okay. It is submitted that the victim witness number 2 PW2 is aged about 12 years And since she has already been examined and cross-examined and discharged by the Planet Trial Court, the calling are paid for re-examination would cause, where have you stated that it will affect her? Unnecessary harassment, and it will amount to a secondary victimization of the victim, victimization of the minor victim. Stop. Call for the scanned copy of the trial court record. Okay.
Yes, Your Lordship. And
Issue notice.
stay there.
Okay. The petitioner shall take steps upon the respondent by a register post with AD, as well as by usual process within 5 days from today. Okay. Stop. In the meantime, the impugn order dated 15/3/2020 in respect of the direction in criminal miscase. There are some other miscase also, it appears by this order
Yes,
in respect of the criminal miscase number.
68.
This is 68,
Yes, 68 of 2025.
not 63.
68, Your Lordship, page number 49. There,
Page 49.
by mistake, maybe they have wrongly listed.
Hmm?
68.
No, here in criminal miscase number 63.
No, Your Lordship, even in the page number 22,
Page
it is
22.
page number 22. Para 14, it is ordered that victim B, PW to be recalled for her examination for determining the limited.
68.
Yes,
But come back to page 9.
page.
Senlal Ronya.
Yes, Lordship.
Here it's 63. You see, just page 20, para 9.
Your Lordship, this must be a typographical error. Your Lordship,
Okay.
it is 68.
Then, okay, 68, huh?
68.
This case number 68, 22, 25. Will remain still the disposal of this petition. Okay.
Your
Yes.
Lordship, any application filed by the other accused person for the re-examination of same victim may be stayed also.
That cannot be. That cannot. Can that be?
My lord, since your lordship has perused the cross-examination and the examination done to
Of
the
his-
victim, so your lordship, now there is nothing to show that there is a requirement of any re-examination, because otherwise, your lordship, since this application is also, if my humble understanding, it's afterthought and just to fill up the loopholes. Yes, your lordship.
That is why
During
I'm
the,
staying.
yes, during
But
the,
in future
during the
future
pendency of this, your lordship, during the pendency of this criminal petition,
Hmm.
if your lordship, the learned court will exercise its power, again exercise its power for re-examination, and if it examine also, your lordship, it will cause great prejudice to the state, your lordship.
So that is why this will be stayed. This is stayed.
State in respect of the present, your lordship,
Present.
and any application for your lordship, re-examination of the present victim, your lordship, which we are saying, your lordship, that may be state, well, that will be the outcome of this, your lordship, criminal
Okay.
petition.
So
We are only,
that means you are expecting that some other accused person may also file a similar
Your
application.
Lordship, they have already filed.
there are
They have
many
already
applications.
filed, but which the POCSO special judge is yet to heard on those matters. So the order has not been passed on those applications, but they have already filed.
The learned special PB further sum is that the other accused persons has also filed a similar application before
Similar
the special
application. The
judge
same,
NDPS. for recalling of the victim B2 for further examination. But in future that it is made clear that if the victim has already been examined, cross-examined and discharged,
Or maybe
In-
it's on the pending applications, which are.
discharged in the discharged by the special court POCSO Act from she shall not be recalled for re-examination. Okay, okay. List this matter after
After 4 weeks, my lord.
4 weeks.
And your lordship, the registry may be directed to reflect the PP of AP in the court list
Okay.
of the petitioner.
The registry shall reflect the name of the PP
PP of AP is
of
AP, your lordship, in the petitioner side, your lordship, as a default, your lordship.
AP in the cause list
Yes,
as a counsel for the petitioner.
yes,
Okay.
your lordship. Obliged.
Yes,
Yes, Your Lordship. This is a petition for discharge.
okay.
Lordship, for quashing of the FIR and charge sheet, Your Lordship.
Yes, what is the allegation?
Your Lordship, the kindly come to the page 20, the FIR, Lordship. Lordship, the FIR has been filed by the respondent number 2, the then district election officer, alleging that 23 officials had not performed the election duty on 17 April 2024. And-
FIR was lodged by state.
Yes. And request the police to take strict action against those defaulter, Lordship. And Lordship, during the course of investigation, the IO had charge sheeted against 15 accused person, Lordship.
Okay.
Kindly come to the piece number 47. 47.
File charge sheet.
Yes, charge sheet, Your Lordship.
What about what is the status of the case then?
Lordship,
Before the trial
the
court?
trial court is charged yet to be framed, Lordship.
Charge not yet framed.
Not
Case
yet
of which
framed.
year?
2024.
Case of 2024. only.
Yes, Lordship.
Okay.
Lordship, further, again, after taking cognizance of the case, the learned trial court had
Case has been taken cognizance.
cognizance and discharged 12 of them. One on,
Okay. That means the charge framed against other accused persons.
Lordship, there is remaining only 3 accused person. Only 3 accused persons is left here, Lordship.
Okay, so rest discharged.
Already discharged. One on
Okay.
direction given by this Honorable High Court.
Okay, then that must be the prima facie case found against these accused persons. Charge framed, that
No,
means,
no, Lordship.
then how it is?
Lordship, I'll come to that, Lordship.
Okay.
Kindly see, Lordship, page number 88. This is the medical prescription of the petitioner number 2, Lordship. At time after attending the election training, the petitioner was suffering from
Page 18.
188. 88.
What is this?
This is medical prescription, Lordship.
No, that is not connected. Where is the last order? Whereby the other co-accused has been discharged.
Discharge order is in Lordship. Annexure 555, page 55, Lordship.
55.
Yes, Lordship. 55. 50,
55.
yes, 55. From 55 to Lordship, from 55 to 67, Lordship. Sixty-seven is the discharge order, Lordship. Kindly come to the 57. 67.
67.
Yes, Lordship.
Just a minute. What is this 50? this order.
Yes, Lordship. Middle portion, Your Honor. The BA is directed to strike the name of accused person Srimati Panimuri Nangaram.
What is BA? Bench assistant.
Bench assistant, Your Lordship.
Remaining 2%. Okay.
And Your Lordship, the annexer F 60.
What happened thereafter? It was fixed on 11-12.
11-12, Your Lordship.
Where is the 11-12 order?
11-12, will only kindly come to the press order, page number 49, Lordship.
Hmm?
Page number 49, annexer D.
It is 4-9.
Yes, Your Lordship.
Yes.
And 50 is the last page, Your Lordship. The case was fixed today for necessary order, Lordship. Page 50, 50.
5-5.
50.
50.
Yes, Lordship.
This is next date only.
Yes, Lordship. Today.
9-6.
Yes, today case
So
is
where is the
fixed.
9-6?
Lordship, it not says.
Today is the 9, Lordship.
This is the last order.
Yes, Lordship. Last order.
So the charge could not be explained.
No, Your Honor.
Not yet explained.
No, Your Lordship.
Okay. Whatever.
So,
maybe.
Lordship,
So what we can do, we will.
so Lordship, kindly come to the page number.
So we will call for the scan copy of the
Yes.
trial court record because on the 9-6 necessary order has been passed, Lordship. So to be passed, Lordship, then today is 7, today is Lordship, 9, Lordship. So
Today is?
Lordship, yes, today is 9, Lordship.
Okay, it is
to-
fixed for
On 9, Lordship, today itself
today.
in order, yes, Lordship.
The same case is fixed today before the JMFC coloring, Lordship.
You are challenging. And then in that case, today they must have passed some order.
Yes, Lordship, that's why,
In that case, we have to challenge.
yes, Lordship.
That I think you may have to challenge because now we do not know what order was passed. Or you have any idea, any order passed by now?
Yes, so next date has been given you.
Hmm?
Next date has been given. Adjourned case, Lordship. I have
No, whether the charge was explained.
No, Your Honor.
We'll call for the scan
Okay.
copy of the case.
Counsel, I'm the counsel in the trial court also.
Have you mentioned the GR case?
Yes, Lordship.
Okay, yes, it is there. Okay, Mr.
P bate.
Hmm?
P bate.
And Lordship, notice may be issued upon response number 2, Lordship.
P bate.
Yes, Lordship.
Then counsel for the petition. This is an application filed under section 528 of the BNSS 2023, praying for quashing and setting aside the GR number 09-2024, arising out of Colorian PS case number 04-2024 under section 166 capital A of IPC, rail with section 134 of Representation of People Act. Start. Call for the scanned copy of the trial court record. Issue notice.
GR number, Lordship, 9/2024.
That is the already recorded. So notice to be issued to whom? You are
Response number 2,
representing the,
Lordship. I am 41, Lordship.
okay, since Miss Melhage appear and accepted notice on behalf of the respondent number, state respondent number 1. No formal notice need be issued to the said respondent staff. The petitioner shall take steps upon the respondent number 2 by a registered post with AD, as well as by user process within 3 days from today. Within 3 days, you take steps upon the respondent number 2
Lordship, make it 1 week, 5 days.
Oh, 1 week, okay.
Yeah, 1 week.
Within 5 days from today, huh? Start, huh? Then, to be listed this,
After 2 weeks, Lordship. In the service. Will
he is
get-
taking steps within 5 days, he will
Or
take
then,
1 week, that means. Then it will be listed after 3 weeks,
Lordship.
okay?
Lordship, then till then interim stay may be suspended.
Lordship, now we'll have to see whether what necessary order has been passed, Lordship.
It may so happen that you may also might have also been discharged, we do not know. You are
No,
not updated.
No, Your Lordship, I'm the counsel in the trial court also. So
Today, how you, then today,
today I
what
have,
happened today?
I have
What
sent-
order was passed?
the case has been adjourned, Your Honor. I have submit letter of absence before the learned trial court.
Have you prayed on before the trial court for discharge?
Yes, Lordship.
It was rejected.
Yes, Your Honor.
Okay, then. No. How many total accused you said?
15, Lordship.
Out of 15, 3.
3, yes, Lordship.
Discharged. Then they are the prima facie. How do we interfere with? No chance. Okay, the interim prayer shall be considered on the next date. List this matter after 2 weeks. Okay.
Much appreciated.
Yeah. Hmm. Hmm. Yes.
Yes, Your Lordship. This is a revision petition, Your Lordship, under 237, Your Lordship, challenging the order dated 16/4/25, Your Lordship, passed by the learned civil judge, senior division, reject my condemnation application,
What is wrong in it?
Your Lordship.
What is wrong in it?
In the
On rejecting? By rejecting what jurisdiction error has been committed?
Your Lordship, not the jurisdiction, but Your Lordship,
This is 115.
yes, Your Lordship.
Revision.
Yes, Your Lordship.
What error has been committed in error?
Error in the sense, Your Lordship, the learned court has failed to appreciate the pleadings that I have made in my condemnation application, Your Lordship. The pleadings in my condemnation application, Your Lordship.
What was your pleadings and not been taken care of? Or not been considered?
Your Lordship, if I may, Your Lordship, there was a kavang that was held in the year.
How many days? 910 days.
Yes, Your Lordship.
How can that be considered?
Your Lordship, but the fact is that the learned court has not appreciated the pleadings that I have made in my condemnation application. Not appreciated the pleadings that I have made in my condemnation
Now,
application.
the clear condoning the delay of 948 days
Yes, Your and 910 days, Your Lordship.
910 days from
Basically,
against the impugned Keba decision.
yes, Your Lordship.
See, from the decision and from the aforementioned, there is no sufficient question. Please, in filing appeal against the impugned Keba decision and so and so. So how can that? What was not considered?
Your Lordship, first of all, there was a continuous trial of settlement between the respondent and the petitioner,
No.
Your Lordship.
But it appears that your, see, the date, calculation of the date, 948 days and 910 days.
And secondly, Your Lordship,
And then, was there any wrong in calculation?
no,
or
Your
what?
Lordship, no, Your Lordship.
Then the learned trial court has exercised his, her discretion, then how do we interfere with? And found that you have not shown sufficient cause.
Yes, Your Lordship, I will do that, Your Lordship. First of all, Your Lordship, there was a first Keba which was held in the year, Your Lordship, 2021, Your Lordship. The first Keba. That is on 12/9/21, Your Lordship. Wherein the Keba has ordered for the payment of 5 lakhs to the respondent. It was a matrimonial dispute, Your Lordship,
Hmm.
to which agreed with the decision of that Keba, Your Lordship, the respondent therein, herein, the respondent herein.
What is the direction to you? To
Uh,
pay 10
Keba
lakhs.
no, Your Lordship. In the first Keba, it was 5 lakhs.
Okay.
And agreed by this decision, Your Lordship, the respondent again has applied for another Keba in another jurisdiction, village jurisdiction, wherein that amount
On the same matter.
yes, Your Lordship, for the same matter, where the amount was enhanced to 10 lakhs, Your Lordship.
The first Keba decided for 5 lakhs.
Yes, Your Lordship.
To be paid to the respondent by you.
Yes, Your Lordship.
And on the second Keba, it was in appeal.
No, Your Lordship. Same, only Keba only, not appeal, Your Lordship. But in the jurisdiction.
Keba.
Yes, Your Lordship. But in the jurisdiction of another village, Your Lordship. The first Keba was of Berung Keba. The second was of Rani village Keba, sir.
You are challenging which one?
Both of them, Your Lordship.
Both.
Yes, Your Lordship.
But then
I-
filing then appeal. Have you filed appeal?
Yes.
That appeal,
Your Lordship.
there was okay, they're barred by limitation.
Yes, Your Lordship. But in meanwhile, Your Lordship, while the second
So
Keba,
even after first Keba also is 900, first Keba 948 days.
I was not agreed by the.
Then for the second Keba 910 days.
Yes, Your Lordship. I was not agreed by the first Keba. I was agreed by the second Keba, Your Lordship, which was held on.
But now you are challenging first and second both.
Yes, Your Lordship.
So you are angry now because there was a double Keba.
No, because of the enhancement of the.
Otherwise, you are not agreed by the first Keba.
No, Your Lordship. In between them, the filing of the appeal before the senior division bench, a senior judge, civil judge, we had
No, that is why I'm saying. Admittedly, there was a delay of 948 days.
Yes, I agree.
From the first Keba.
Yes, I agree.
And admittedly, there was
No,
a
no, no.
delay of 910 days from second Keba.
Yes, Your Lordship.
Now, not on merit, but on condemnation that you have not shown a sufficient cause
Yes, Your Lordship.
for not filing the appeal on time.
My pleading
So
in
on
the.
that only it was disposed of.
Yes.
How to?
My pleading in my condemnation application was, Your Lordship, the Kebang of the Rani village, which was 21st, held on 21st October 21. Still date, I have not been received, furnished with the certified copy of that order, Your Lordship.
That probably was explained. And that explained was taken.
Yes, I have already taken
account.
that. Yes, ground.
After consideration of that explanation given by you, thereafter only it was probably, it appears that this application was disposed of.
But in between, Your Lordship, there was a series of incidents, which in my humble opinion,
Where have you explained? What is your explanation?
Your Lordship.
Because there is a delay of 490, so 948.
I agree, Your Lordship.
This is not on merit, first of all.
Yes, Your Lordship.
Whatever may be rightly or wrongly decided, decision of the Keba is not connected. But then the delay in filing the connected appeal before the appellate authority,
Yes, Your Lordship.
that only was considered.
Yes,
It was
Your
not discussed on the merit.
No,
of
no,
the
I'm not
case.
on the merit, Your Lordship.
That is
Now
why
also.
your explanation was duly considered by the Learned Trial Court, it appears, extensively discussed. And not satisfied, you could not explain properly the day-to-day delay.
First of all, Your Lordship, I was a villager. I was not aware of the law of limitation, Your Lordship.
Now thereafter, what happened? Any execution, anything? What happened thereafter?
Till that, I have been informed that no execution petition has been filed till date, Your Lordship. No execution petition has been filed till date, Your Lordship. In
Part. This is item 2. Mr. Y. Ram, Learned Counsel for the petitioner. You have made party to whom?
Only one, Your Lordship. One respondent.
Okay. This is an, okay, by filing this application under Article 227 of the Constitution, Indian Constitution, the Constitution of India, read with section 115 of the. See, you have to satisfy this revision petition on the jurisdictional questions, and then it appears that you have not properly, I think, explained also, and then since the Learned Trial Court has exercised its discretion, it's very difficult. You could not show the jurisdictional error here. Section 115 of the Code of Civil Procedure, 1908. Start. Whereby, 1908, not start. Whereby. Just a minute. Okay. By filing this under circumstances, the petitioner has challenged dated 16/4/2025, passed by the Learned Civil Judge Senior Division Pasigat in interlocutory application IN number 23/2024 in civil Keva appeal number 10/2024, rejecting whereby the condemnation petition filed by the petitioner was rejected. No, just a minute. 10/2024, rejecting the application for condonation of delay of 948 days and 948 and 910 days in filing the connected appeal against the Keba decision dated 12/9/2021, within bracket Borum Kebang bracket close, and 21/10/2021 within bracket Rani Kebang bracket close. Stop. All for sorry.
Your Lordship,
Whether the record is necessary. Call for the scanned copy of the trial court record. Is it necessary or not? Whether the record is necessary or not.
Your Lordship, I think I have submitted all the
Okay.
orders of the Lord Court, Your Lordship.
Okay, then leave the record. Issue notice. Returnable by. The person stays at Pasigat village.
Village, Your Lordship.
Somewhere. Okay, then it will be 4 only.
Yes, Your Lordship.
Okay, returnable by 4 weeks. Stop. The petitioner shall take steps upon the respondent, the sole respondent, by a register post with AD, as well as by usual process within 7 days from today. Then.
Yes, Your Lordship.
Okay. List this matter after 4 weeks. Okay.
My humble prayer would be, Your Lordship, maybe the
It was only no.
operation of the Kebang maybe.
No,
stayed, Your
the
Lordship.
final decision only, because you are challenging the discretion exercised by the trial court
Yes.
not be, of course, possible to interfere with. But since you are alleging the very order
Yes, Your Lordship.
to separate Kebang
Yes, Your Lordship.
on the same matter, decided 1 for 5 lakhs, 1 for 10 lakhs.
Yes, Your Lordship.
Taking that into account, probably, if there is any direction.
In that case, then Your Lordship, records may be called from the trial.
Then,
court.
before the notice, call for the scanned copy of the trial court record. Okay.
Yes, Your Lordship.
Okay.
Obliged, Your Lordship.
Okay. So we'll continue after lunch.
And 35(3) 2023, Lordship. Lordship, on
What is this 316? 3165?
this is criminal breach of trust and criminal intimidation.
Okay.
Lordship, on 17/3/2025,
What is
Lordship,
35?
That is common intention, Lordship.
Hmm?
Common intention, Lordship.
Okay.
Lordship, on 17/3/2025, Lordship, both the petitioners were granted interim protection, Lordship. Thereafter, Lordship, we appeared before the investigating officer and we have recorded our statement, Lordship.
Okay.
Today's
So
picture.
whether you were arrested?
No, Lordship.
Not arrested.
Not arrested, Lordship. They are in the, before the IO, we took bail, Lordship. We recorded our statement and we completed the procedure for submitted our bail bonds, Lordship.
Wrong submission, Lordship. I have received this, Lordship. They didn't.
Okay.
No, we appeared on 26th or 27th of May, Lordship. CD2 क्या है?
Despite getting interim bail, Lordship, they didn't appear before the IO. No OC, Lordship. So their bail may be cancelled, Lordship. Interim may vacate, Lordship.
What is his name?
Atul Sharma, Lordship.
Atul Sharma and Ankit Mishra, Lordship. We appeared before the IO on 26th or 27th of May, Lordship.
This is 14th May.
Lordship. Thereafter, Lordship, we appeared, Lordship, on
After 14th May.
after 14th, Lordship. 27th, I think, Lordship, both of them appeared and recorded your statement, Lordship. Up to date CD may be called for, Lordship.
Latest status report. Latest status report.
Lordship.
Status report, Lordship.
So this is 14th May only.
Now, yes, Lordship, 14th May, on 14th May, Lordship.
Both of them appeared, Lordship, and I accompanied them to the Naharlagun PS,
You
Lordship.
produce a updated status report if they have already appeared. It's only notice here, see, and then thereafter, she submits that thereafter only these. accused
Lordship,
persons
because
appear.
both of them reside outside of outside Arunachal Pradesh and outside of Assam also, Lordship. They are residents of Uttar Pradesh,
So
Lordship.
according to you, they are not cooperating, but it
Yes.
appears that if they have already appeared, their police.
Yes,
inspection
Lordship.
also
I
required.
accompanied them to the Naharlagun PS on
Next date may be.
next date, maybe fixed, Lordship.
So that I can.
When?
Next week, Lordship.
Next week?
Yes, Lordship.
Next week, Lordship, fix a date, Lordship.
Next week?
Lordship.
Or Miss?
B. Sharma, Lordship.
Miss Samalar, counsel for the petitioner. Mr. Lloyd and DP. Submits that he has a status report dated 14/5/2025 and prays for some time to produce the updated case diary as well as the status report. So, age requested. List is met again on 16. Next week would be
15, Lordship.
15.
15, Lordship.
Huh?
15. 18, Lordship, then.
Okay,
Lordship, 18 then.
18. Okay. 18 June.
Interim may be continued.
The interim or the past earlier can continue to. Then. Okay.
Next day, Lordship. Much of them.
Yes.
May I please, madam?
Hmm.
Madam, this is a bail application filed by the father of the accused. Actually, madam, may kindly come to page number 16. That is FIR. Actually, it was a missing report.
This is regular bail application.
Yes, madam, regular bail application.
Page
16, madam.
6.
16.
Yes.
Yes. May I read mine?
Hmm.
To the officer in charge, subject FIR missing report. Sir, madam, I have the honor to inform you that on so and so dated at 1:30 AM, my underage niece, Miss so and so was kidnapped by 3-4 miscreants. From the lodging of this missing report, this FIR was, the accused was arrested. That is page 17 or page.
Arrested.
Yes, page
This was
20.
17.5.
Yes, page.
He was arrested on 19.5.
19.5, yes.
Okay.
Actually, Your Honor,
How many accused are there?
3 accused was there.
3.
Yes, actually what happened is that, Your
You are
Honor,
for 1.
I'm for the accused Nyari Tugu.
Hmm?
Nyari Tugu.
Okay.
I'm for the accused
You are
Nyari Tugu.
only one accused.
Yes, only for the 1 accused. The other 2 accused, Tadar Seba has already been granted by bail by the.
Okay, so earlier your bail was rejected.
No, Your Honor. It was not rejected, Your Honor.
Not rejected.
Actually,
What
I
is
have
this?
directly approached this honorable court because at the time of filing this bail application, the honorable special judge was on leave. So I've mentioned in paragraph here in my petition also. That's why I've directly approached this honorable.
Where have you stated that he was on leave?
Thank you. Yes, para 9. Page 9, para 9. That the applicant has, para 9, yes.
Hmm.
The applicant has directly approached this honorable court as because the court of so and so is on leave. Further, accept this bail application. Moved on behalf of the accused, no other similar bail application is filed. Actually, what happened is that.
Whether the report was called for?
Yes, CD was called for.
CD was called for.
Yes.
Yes, I state that they have completed their custodial inquiry, custodial, not necessary.
And moreover, Your Honor, I was falsely implicated in this case, actually. I was falsely implicated in this case because what happened is that, Your Honor, my friend who was already granted bail, this Tadar Seba, I was accompanying him to meet his another friend who is the main accused here in this case. Your Honor. And when we met him at Itanagar, that another friend asked him to drop to his location with his girlfriend. Your Honor. I don't know the main accused of this case and the victim of this case. And after dropping them, I and Mr. Tadar Seba, the another accused, has left the place. And the other accused, Tadar Seba, has already been granted bail, in this case.
So, what is his role?
I have no role, Your Honor.
Sana BP? Lordship? What is your submission? What is the
Since Lordship ever with the ex versus state Lordship. Ex versus state in offense in serious offense like rape, murder, and the bill should be not given to the ex. Also,
where is the statement of the victim?
victim is it? May I, Lordship?
Whether the victim has given statement before police, 164 statement.
Yes,
given. Okay. Police statement and 164 statement.
Yes.
What was the age of the? Lordship? Okay.
Status of IO is Lordship. Status report of IO is at page number 1, Lordship, front page, Lordship.
That, what was the name of the accused?
Nyogi Nyari Tugu. Nyari Tugu. Nyari Tugu.
Nyari? Yeah.
This application is filed by the father of the accused.
Okay.
Accused name is Nyari Tugu. Yes.
So, in her statement, his name doesn't appear. Isn't it? She did not take the name of the accused, yes, applicant, the present applicant. Whether she has taken his name in the police statement, have you seen the police statement? Have you gone through?
No, Lordship. I've only gone through the statement 164, Lordship. Only 164.
You should mark next time when you present. You
Yes,
mark the
yes,
relevant,
yes. Extremely sorry for
police
that.
statement, 164 statement, the relevant, all the relevant. Otherwise, it takes time to go through.
Yes, yes, Lordship.
Yeah. Hard. Mr.
Yes,
Chetri,
sure.
S. Chetri, Bank Counsel for the petition. Also hard, Mr. Lloyd, and PP for the state staff. The case that is called for has been produced, and I have produced the same stuff. Before that, this is the bail application while on the section 483 of the BNSS 23 for grant of bail to the accused Nyari Tugu, alias Nanu, who has been arrested in connection with arrested on 19/5/2025 by the Women Police Station Danaga in connection with Women Police case number 34/2025 under section 137(2)(3) within bracket 5 of the BNSS 2023, read with section 4 within bracket 1 of the Protection of Children from Sexual Offense POCSO Act 2012. Then the case study is called for has been produced, and I have produced the same stuff. Yes, that as well as the status report, is called for has been produced stuff, and I have produced the same stuff. As per the record, the record reveals that in her 164 is what BNSS corresponding section under BNSS is
41. 41.
okay.
41. Correspondence.
Where is it? 183.
183.
183. 183 share statement. The victim did not implicate anything against the accused. Not present accused. The petitioner is somebody else. Yes. Okay. Accused. His name. Nyali. What was his name? Nyali.
Nyari Tugu.
Nyari Tugu. Yes. As per one, this is 183. As per the statement of victim under section 183 BNS says she is aged about 17 years and she has not made any allegation against the present accused, Nyari Tugu. The status report of the IO also reflects that the accused did not make, the victim did not make any allegation against the present accused, and the investigation of the case has almost been completed, and the custodial remand of the accused Nyari Tugu is no longer required. Stop. The Land Council, the Land Council for the petitioner submitted. Who has been released? Main accused.
My lord,
Who co-accused, who was released here?
the another accused, co-accused is Tadar Seba,
Okay.
who was my friend
The-
actually, yes.
The record
Tadar
reveals that when the the main accused, what is the name of the main accused?
It's Arpan Thapa,
Arpan
Arpan
Thapa and the victim were in the another room. The present alleged accused and one Mr.
Tadar Seba,
Tadar Seba
yes,
were sitting outside
yes,
the another room, veranda of the another room.
yes,
And he further submits that the co-accused, namely Tadar Seba, has already been enlarged on bail on by which court?
by Juvenile Justice Board, my lord.
Oh, he was juvenile.
Yes, my lord.
Okay. He is being a juvenile is on bail.
30 May, my lord.
Okay, on bail. So, and what is your age? The present accused?
I'm 18 years, just completed my class 10
Okay. He
examination.
is studying in class?
Now I've appeared my class 10 exam, my lord. I've given the
Recently appeared class?
10.
10. Okay. The further submits that the accused, the alleged accused has recently appeared class 10 and his age is, he has just crossed. Well, he is just he is 18 years old. Okay. 18 years old. And in the event of grant of bail, he is ready to cooperate and cooperate with the eye of the case. And to appear for the investigation and for trial. So, considering the nature of allegation and the nature of allegation and nature of the case and the materials on record, and as the investigation of the case is almost been completed, and the IO has also indicated that his further custodial remand is no longer required. This court is of the opinion that the accused, this court is of the opinion that the accused, that the bail prayer of the accused can be considered at this stage. So accordingly, the bail, accordingly, the prayer is allowed. So the accused is directed to be released on execution of a bail bond of rupees 15,000 with one surety of like amount, with the satisfaction of the executing authority, the satisfaction of the special judge. Also, special judge
Boxo, my
UPI.
UPI.
Special judge also at UPI with further condition that the accused shall cooperate and appear before the eye of the case as and when called for, and that he shall not tamper or tamper with the evidence of a case in any manner. Stop. With the above, this bail application stands disposed of.
May I, my
Return
lord?
the case diary.
Only one small prayer, my lord. I'm just a contingency sanitation driver with regard to the.
You are
Sa-
contingent driver?
Yes, the
You said you are
applicant,
just
the
yet
father of
to
the,
appear
no,
class
the
10?
the father of the applicant. This is a contingency sanitation driver with regard to the, this bail bond amount, my lord. Maybe reduce little.
Make it 10,000. 10,000.
Obliged.
Your lordship, come to FIR, page number 18. Page 18.
What is page 18?
So FIR says that it is to inform you that on 11/4/2025, 8:23:10 hours, a reliable information was received that few person in a Mahindra Scorpio bearing registration number so and so are in possession and transporting huge quantity of narcotic drugs suspected to be heroin from Nagaon and are going to sell the narcotic contraband at Bandadua market. Accordingly, learned SP Naharlagar was intimated. The same was duly reduced into writing. Further, learned SP Naharlagar verbally directed self to constitute a team. Subsequently, self along with ASI SK Tiwari, ASI Rajbar, Head Constable T. Bomdum, Constable R. Siring, Constable and Constable A. Mishra left PS to lay trap and to apprehend the suspected individual by GD number 19/2005 dated 11/4/2025 8:23 hours. Further, independent witness were informed to witness the search, seizure and sealing. If the information was reduced, if the information was true, and if drugs were found, accordingly, the team laid trap at Bandadua market area, and on identifying the suspected vehicle, the police team intercepted the vehicle at Bandadua market and apprehended the accused person identified as Emmanuel Hussein and Emmanuel Hakiu and Ainul Hakiu. So accordingly, a search was conducted upon and before conducting body search, the provision of section 50 of the NDPS Act was duly explained and accordingly served. On consent of allied accused person, their body was thoroughly searched, but no suspected item contraband were recovered. Further, on search of vehicle 4 number of showcase containing oranges color powder suspected to be heroin packed inside a black color polythene bag was concealed under the driver's seat. On weighing the narcotic substance, total gram is 46.70 gram, your lordship. Your lordship, the fact is that on the day of occurrence, the accused person was proceeding to Bandadua from Nagaon. He was traveling as a co-passenger in a vehicle from where the drugs was recovered. Your lordship, on reaching Bandadua, his body was conducted, the body search was conducted, but nothing was recovered. Your lordship, at the time of recovery, the accused person was not mentally aware.
Where from these substances were recovered from?
Recovered from vehicle.
Vehicle.
It was
You were traveling as
a co-passenger.
co-passenger.
Your lordship. And
Okay, who else were arrested from this? And all the
3 accused were.
3 accused,
Yes,
including the driver.
Driver, your lordship.
Okay.
Driver.
Among these 4 persons were
3
arrested.
persons.
3. From these 3 persons, from whom the material was, the substances were recovered.
The substance was not recovered from
Okay, from
anyone's
vehicle.
possession, your lordship.
So, okay.
So the driving, your lordship, the accused person in bail application 65 was driving the vehicle.
Who was
Accused
driving?
person in bail bail application number 65. There are three, Your Lordship, arising out of the same FIR.
Okay.
3 bail application has been filed.
Pre-bail application
Yes, Your Lordship.
before this court.
Yes,
Okay, what about the bail application of other co-accused?
co-accused, all the co-accused, Your Lordship.
They are pending before this court?
Yes, before this
Okay,
court.
none of them have been now
Granted
so
bail,
far
Your
granted
Lordship.
bail.
Yes.
So if you have
Your Lordship,
there's a case diary?
Yes, my lord, it's a, so far as the allegation is concerned, it's a open shut case. Your lordship will kindly see the statement of 3 of the accused. They have clearly admitted their involvement because 3 of them, they have contributed the money and they brought it from one person which has been disclosed by one of the accused. His name was Hibjul. From him, they have procured the contraband substance. They came toward Bandardua to sell the same. 3 of them. On the bottom side, your lordship will find
Whether the contraband substances which was recovered from the vehicle were later on identified that it was carried by him.
Yes, your lordship.
All of them?
Yes, 3 of them.
Okay.
Your lordship will find in the serial number 1, it's written Iman Anamul Hussain. Your lordship will find there. They 3 of them will admitted, your lordship.
Okay, you have filed these 3 bail
3
applications.
is connected, your lordship. The 3 bail application from 11 to 13 for 3
11 to
respective
13,
accused.
11 to 13.
Yes, 11 to 13.
Okay.
Yes.
Your
3
Your
of
Lordship,
them, your
the
lordship.
here is,
Just a minute, huh? Which one?
One, your lordship will find the serial number 1 is written
Statement of?
Imanul Hussain. The number, your lordship, bottom page number 9. In the bottom part, your lordship, page number 9, bottom.
Okay,
Names,
bottom
yes,
part.
from there,
Imanul.
your lordship will find.
Yes, their own name. He's a cab driver.
no, Your Lordship, that vehicle
It
was
became
taken on
that-
rented.
That vehicle was hired by them, your lordship, and the vehicle was seized from this person, Emmanuel, along with the contraband, because
Consumer also.
yes, consumer as well as peddler, your lordship. Otherwise, your lordship, the section is not registered under section 27A for trafficking, but it's under 21B for intermediate quantity.
Intermediate.
Yes, your lordship. 3 of them had admitted their guilt, your lordship.
Okay, he will give detail first time, second time,
3rd time he caught.
third time.
And serial number
And equal,
and serial number 2 is
Emmanuel also.
yes, your
Serial
lordship.
number 2 also.
Yes, your lordship.
I stated almost as,
Imanul Haq.
okay, he was a
Bail
buyer.
number 64.
Hmm?
Bail number 64, your lordship.
Okay.
Imanul Haq.
4. Okay, so he also added something that they all contributed.
Yes,
3,000
contributed
each.
3 of them. And your lordship in BN number 63,
Ainul.
serial number 3, Ainul Haq. He also admitted.
Okay, he was arrested in connection with some other similar case also.
Also,
earlier.
yes, your lordship.
Anything else beyond?
Yes, Your Lordship, come to page number 22.
Just a minute, huh?
Last page is of the CD is the seizure list, your lordship. There, your lordship, in the bottom part, it is clearly been reflected. 4 of them were inside the vehicle from where the contraband substance has been recovered. Seizure list. Last page, pardon. Bottom in margin, your lordship. The suspect,
Page 22.
yes, your lordship. The suspect narcotic substance were packed inside a black polythene bag which has concealed under the driver's seat of the seized
Okay.
vehicle. Further,
Okay,
3
okay.
persons. Yeah, they 3 were inside the vehicle. That is not disputed, man.
Yes, anything else?
Yes, Your Lordship, first thing, Your Lordship, the contravent was recovered, but it was not recovered from my possession. And the manner in which the police have arrested me is totally in violation of Article 22. Ground of arrest has not been communicated to me, to the accused person. Your Lordship, kindly come to 22, arrest memo.
Ground.
There is nothing in the arrest memo which disclosed that the police has communicated the ground of arrest to the accused person. Your Lordship, in the Supreme Court, Your Lordship, in the case of Bihan Kumar, has clearly, Your Lordship, say that the non-compliance of a constitutional requirement and statutory mandatory be should render the arrest illegal. Your Lordship, the coordinate bench of this honorable court, in a number of cases, Your Lordship, particularly in BA number 3444, while taking note of the determination made in the judgment of Bihan Kumar, released the accused, granted the accused person on bail, holding that if the police person failed to inform the accused person the ground of his arrest, it is clearly violation of Article 22. Your Lordship, and Your Lordship, in the Bihan Kumar, Your Lordship, Parveen Pukia Yasra versus State and City of Delhi.
There are some order passed by this court also.
Yes, Your Lordship, all are distinguishable. I will distinguish it, Your Lordship. I have a judgment also where it says in NDPS case compliance of section 57 is not. I will come to that. Let my brother first argue on that. Then I will come to that.
Your Lordship, paragraph 47. Page 38. Now coming to the aspect as to whether the ground of arrest were actually conveyed to the appellant in writing before he was remanded to the custody of the investigation officer. We have carefully perused the arrest memo and find that the same nowhere conveyed a ground of on which the accused was being arrested. The arrest memo is simply a pro forma indicating the formal reason for which the accused person being arrested. It may be reiterated at the course of the repetition that there is a significant difference in the phrase reason for arrest and ground for arrest. The reason for arrest as indicated in the arrest memo are purely formal parameter, that is to say, to prevent the accused person from committing any further offense for proper investigation of the offense, to prevent the accused person from causing the evidence of the offense to disappear or tamper with such evidence in any manner, to prevent the arrest person from making inducement, threat or promise to any person acquainted with the fact of the case so as to dissuade him from disclosing such fact to the court or to the investigation officer. This reason would commonly apply to any person arrested on charge of a crime where the ground of arrest would be, whereas the ground of arrest would contain all such detail in hand of the investigation officer which necessitate the arrest of the accused person. Simultaneously, the ground of arrest informed in writing must convey to the arrested accused all basic fact on which he was being arrested so as to provide him an opportunity of defending himself against the custodial remand and to seek bail. Thus, the ground of arrest would invariably be personal to the accused and cannot be equated with the reason of arrest which are general in nature. Your Lordship, here in the case, Your Lordship, while arresting me, the ground has not been communicated. In the seizure memo, it has says that they were found at the time of seizure, Your Lordship, the accused person were found in the vehicle. Your Lordship, of course, Your Lordship, I was traveling from Guwahati, from Noga to Bandardua.
Okay.
Merely I was.
Have you annexed the arrest memo?
Arrest memo.
Is
Page
there
22, my lord.
20 in the petition?
Annexure 3.
Okay.
Serial number 30 is the ground of arrest and reason of arrest.
Nothing.
No, it's there. Your lordship may see the left side, not the right side. Right side is yes, is written. Your lordship, below reason and ground of arrest K, prevent accused from committing any further offense. Now, your lordship, my brother is trying to highlight that the reason of arrest cannot be equated with the ground of arrest. That is absolutely correct. But this is a NDPS case. Your lordship is aware of section 37. What is the second condition says? The court has to see that while on bail, the accused is not likely to commit any offense. So this reason clearly, in fact, your lordship, connected with the second condition of this section, it says prevent accused from committing any further offense. My brother is correct, your lordship. So far as it should be very personal. Now, your lordship will find the section 50 application also, section 50 authorization, where the accused has been authorized the police to make personal search. At that point of time, it has been verbally informed to the accused that there is a suspect that you have in possession of contraband substance. For that, the police has made a body search for which they have authorized. Your lordship, we have to understand it is not that simple, your lordship, ground of arrest. It has to be understand why ground of arrest is normally communicated, so that the accused should get take recourse of the any legal, your lordship, remedy if he has been arrested by the concerned authority. So now, your lordship, so far as the reason of arrest is concerned, your lordship will find in serial number 30, where it says first, prevent accused from committing any further offense. Yes. For purpose of investigation offense. Yes. To prevent the accused person from causing to evidence of the offense to disappear or tampering with such evidence in any matter. Yes. To prevent the accused from making any inducement, threat, or promise to any person acquainted with the fact of so and so, as unless such person is arrested, his presence in the court. Your lordship, here the important aspect for ground of arrest is to prevent the accused from committing any further offense, which, your lordship, also flow from section 37 of the NDPS Act, because this is the second aspect which court has always considered when offense fall under the NDPS Act. No doubt it will be confined to specific provision of the NDPS like 27A and, your lordship, this offense involve commercial quantity. But it statute itself, special statute itself, recognize that to prevent someone from committing further offense, that is also one of the ground for rejecting the bail. Then why is on for arresting the accused? This is rightly done. And second part, your lordship, so far as the ground of arrest is concerned, is provided under section 57. Your lordship may kindly come to NDPS Act, your lordship. No doubt it's flow from Constitution of India. This aspect has already been considered by the Honorable Supreme Court. I will, your lordship, later on rely the judgment. Your lordship, section 52 of the section 52 of the NDPS Act.
Yes.
Any officer arresting a person under section 41, 42, 43 or section 44 shall, as soon as may be, inform him of the ground for such arrest. It's recognized by the special act itself, section 52. Now, your lordship, compliance of this provision, although I am not on that, we have complied, but even if it is not complied, what Supreme Court says, your lordship rely the judgment of the Supreme Court. Your lordship, the Bihan case, my brother, which is relying, that was not dealing with the NDPS special statute. And the Purcasto case was confined to preventive detention. Your lordship, I will come to the preventive detention also. Now, your lordship may kindly come to, this is AIR 2000 SC 3661, para 6 and 7, your lordship. I will start from 5. And your lordship, bench with same strength of Bihan. Division bench, Bihan is also division bench, your lordship. Even if there is any conflict, the former will follow, your lordship. This court has laid the parameter to be followed while considering
reading which para?
Para 5, my lord. Second page.
Okay. Yes.
This court has laid down the parameter to be followed while considering the application for bail moved by accused involved in offense under NDPS Act, White Union of India versus so and so, it is unnecessary for us to repeat those parameters over again. We have no doubt that learned single judge has not followed the aforesaid parameter in this case. In light of section 37 of the Act, no accused can be released on bail when the application is opposed by the public prosecutor unless the court is satisfied that there are reasonable grounds to believe that he is not guilty of such offense and that he is not likely to commit any offense while on bail. It is unfortunate that matter which now is 11, Your Lordship. It is unfortunate that matters which could have been established only in offense regarding compliance with section 52 and 57. Now 52, Your Lordship, Supreme Court says, have been prejudged by learned single judge at the stage of consideration for bail. The minimum which the learned single judge should have taken into account was the factual presumption in law position that official act have been regularly performed. Such presumption can be rebutted only during evidence and not merely saying that no document has been produced before the single judge during bail stage regarding the compliance of the formality mentioned in these two sections. So now, Your Lordship, here 57 or 52 of the NDPS Act, it speaks about the communication of ground of arrest. And here, Your Lordship, even in arrest memo, it clearly reflects that to prevent him from committing further offense. And Your Lordship, it is a fact that before them only, Your Lordship, the contraband was seized from their car.
Your Lordship,
And-
cars were taken on rented, Your Lordship.
Let me complete first. And second, Your Lordship, so far as Your Lordship, the compliance of the ground of arrest is concerned, it has been dealt by the Honorable Bombay High Court in 1988 BOMCR 118. Here also, Your Lordship, that aspect has been distinguished. If it is preventive detention, no doubt in written it has to be communicated. But if it is not preventive detention, if it is connected with the NDPS or other offense, then also, Your Lordship, there is no any requirement of communicate in writing. It has to be established by no doubt by the prosecution itself. And same is the finding in Bihan also, Your Lordship. Bihan, it says writing is not mandatory. Now, Your Lordship, may come to para 13, Your Lordship. Now, as far as the contention of Mr. Marchant regarding the requirement of provision of section 50 of CRPC being interpreted in the light of provision of Article 22(5) is concerned, I think the submission cannot be accepted. There is basic and fundamental difference between the person detained under provision of law providing for preventive detention and detention of the person on acquisition of commission of an offense. In the case of preventive detention, the person is detained without trial and he has only the right to make a representation. The purpose of communication of ground of arrest to the detainee is enable him to make a purposeful and effective representation. Therefore, under Article 22(5), the basic fact constitute the ground have to be imparted effectively and fully to the detainee in a writing in a language which he understands. However, in a case of a person arrested on acquisition, he is required to be produced before the magistrate within 24 hours. He has the right to consult and to be defended by a legal practitioner of his choice. The purpose of communication of the ground of arrest is to enable him to apply for release on bail when he is produced before the magistrate. Therefore, the principle laid down in decision in cases of preventive decision and the provision of Article 22(5) cannot be placed into service for appreciation the ambit and scope of the provision of Section 50 of CRPC. However, provision of Article 22(1) are relevant, which lay down that no person who is arrested shall be detained in custody without being informed as soon as may be the ground of such arrest, nor shall he be denied the right of consult and to be defended by the legal practitioner of his choice. Provision of 50 of the CRPC by lay down that every police officer or other person arresting any person without warrant shall forthwith communicate to him the full particular of the offense for which he is arrested or other ground for such arrest. Particular already is there, Your Lordship has seen the arrest memo. Now, the provision of the CRPC contemplated that the accused person arrested on acquisition of non-bailable offense has to be produced before the nearest magistrate within period of 24 hours. And his further detention in custody, whether police or judicial, beyond 24 hours has to be under the authorization of the magistrate, which authorization cannot be for more than 14 days at the time. Secondly, depending upon the nature of the offense and punishment prescribed therefore, such authorization cannot go beyond 60 or 90 days, and thereafter, whatever may be the offense, if the accused offer bail and charge sheet is not filed, the court provides that such person shall be released on bail. Provision of Section 50 of the Code of Criminal Procedure will have to be appreciated, understood, and interpreted in the light of all these provisions. In light of these provisions, I do not think that the communication referred to in section 50 of the CRPC must be every case in writing. What is important is communication or knowledge or information regarding the particular of the offense for which arrest is made or other ground for such arrest. Provision of section 50 of CRPC provide that the police officer shall forthwith communicate to him the full particular of the offense for which he is arrested. An act can be said to be done forthwith if it is done with all reasonable dispatch and without avoidable delay. It can be interpreted to mean as soon as possible without any. In the fact and circumstance of the case before me, it is clear that the accused were arrested while they were in the possession of white powder suspected to be heroin weighing about 1 kilogram. The fact further disclosed that accused number 1 and 2 were attempting to flush out the said powder in the toilet. The police officer has stated before the court that he had orally communicated the reason of their arrest to the accused. Further, in the remand application, full particulars of the offense are disclosed, and admittedly, this remand application is made at about 11 a.m. on 27 October 1987. Copy of Panchnama disclosing further detail was also admittedly served to the accused within 24 hours. If these glaring facts are taken into consideration, the plea of accused on the next day before the learned magistrate that they were not communicate the full particular of the offense for which they were arrested or other ground for their arrest appear to be palpable unreasonable. Secondly, the word used in Article 22(1) are that no person arrested shall be detained in custody without informing as soon as may be of the ground of such arrest. Thus, if the person is not informed as soon as may be, his further detention may become invalid or unlawful, but it cannot be said that his initial arrest itself become illegal. If these facts are taken together with plea of police inspector that he has orally communicated the particulars of the offense to the accused, and with the further background that the accused in present case were caught in possession of heroin weighing so and so, I think the provision of 50 of CRPC in this case were fully complied with, and it would be unreasonable to hold, as unfortunately the learned additional Chief Judicial Magistrate has held, that the provision of section 50 are not complied with, and therefore the accused are entitled for bail. As far as 3 cases relied by merchant and referred to above by me are concerned, with great respect to the learned judges, I am unable to subscribe to the view that non-compliance with the provision of section 50 of CRPC render the arrest of the accused concerned illegal. At the best, further detention without complying with the provision of section 50 may become illegal. However, in view of the fact that I am holding that in the fact of the case before me, provision of section 50 of the CRPC are fully complied with, it is not necessary for me to decide this issue as to effect or non-compliance of the provision thereof. In view of it was interfered. So now, Your Lordship, will see the arrest memo. Your Lordship, I have already indicated, Your Lordship, and here offense has already been given. If it is not a case where, Your Lordship, only arrest memo has been given, nothing explanation is there. NDPS clearly reflected, my Lord, and they have duly received the arrest memo, their signature is there. And secondly, Your Lordship, in section 50 also, they have made aware of the fact that there is a suspect that they are in the possession of contraband substance, which is the part of the case diary. There also they have put their signature. Now, how they can say that they don't have communicated, they have not been communicated with the ground of arrest? And here, Your Lordship, the K prevent accused from committing any further offense. Definitely, Your Lordship, there will not be an exhaustive, Your Lordship, ground of arrest. Everything will be illustrative. It depends on fact and circumstances of the cases, my Lord. And so far as K is concerned, Your Lordship, this is in fact the ground for rejecting the bail in section 37, my Lord. So they cannot say that ground of arrest has not been communicated.
Your Lordship, the ground of arrest, Your Lordship, the Supreme Court, Your Lordship, in Bihan gets exhaustively explained the difference between ground of arrest and the reason for arrest. And the learned PP, which is indicating that these are the ground for arrest, is a formal parameter. This applies to every arrested accused person, Your Lordship. As per the judgment, Your Lordship.
In the format where the reasons for arrest is to be stated in 30.
30, Your Lordship.
Yes, sorry, my Lord. Yes, 30, my Lord.
Yes, in 30.
Your Lordship, ground of arrest contain all the detail which necessitate the arresting authority to arrest the accused person.
And my Lord, after Bihan also, one more judgment is there where it says, even if the arrest memo mentions something worthwhile, that will suffice. There is
Where do we find?
worthwhile, your lordship, I don't have the judgment, but I don't have the copy, but your lordship, here is the judgment, your lordship. I will just, your lordship, read out. It's not that lengthy or lengthy one. Ashish Kakkar, your lordship, in SLP 1662 2025. After Bihan only, your lordship. May I read the judgment, your lordship?
Yes.
Why the present appeal? The applicant has challenged both his arrest and remand order dated so and so on 3 grounds. Namely, there is a clear non-compliance of the mandate under section 41A of CRPC. The applicant was not heard at the time of remand, and the ground of arrest as mandate under section 50 of the code have not been furnished to the appellant as against mere arrest memo. Here also, your lordship, this case is not concerned with the NDPS. It's general offense, but still, your lordship, we are inclined to consider only the last issue raised by the appellant with respect to the non-furnishing of the ground of arrest. Upon perusing Annexure P3, we can see that what has been provided to the applicant is only an arrest memo in the prescribed format, which is meant to be given to the appellant by the way of an intimation. It has been filled up with the name of the applicant along with the place of arrest. Additionally, it has been written that he has been arrested based upon the statement of co-accused. We are in agreement with the submission made by the learned senior counsel appearing for the appellant that the said arrest memo cannot be constituted as a ground of arrest, as no other worthwhile particular have been furnished to him. Now, your lordship, here Supreme Court is indicated as no other worthwhile. So something worthwhile should be there so as to substantiate the ground of arrest. That being a clear non-compliance of the mandate under section 50 of the code, which has been introduced to give effect of section 22(1) of the Constitution of India, we are inclined to set aside the impugned judgment. So here, your lordship, only arrest memo has been given, nothing worthwhile regarding his ground of arrest. Basing on that, the bail was granted. And so far as the fact is concerned, even in this case, the fact is regarding, the offense is regarding 384, 420, 468, 471, 509 of the IPC. NDPS was not there. And now, your lordship, I will come to all the judgment. Now I will come to Bihan also. Your lordship, in Prabir Prukastia case, Prabir Prukastia case, very interesting, your lordship. This case was a UAPA Act under.
Yeah.
It's a preventive detention. For that, your lordship, communication is required because the person has been prevented from committing any offense. It is on anticipation he has been prevented, and there is no any other source that he will take any recourse. So he have to, in Bombay High Court judgment, your lordship, I have relied. In preventive detention, there is requirement of giving him the giving in writing so that he can go for representation. And second, your lordship, Bihan case is also, your lordship, not connection with the NDPS.
In prevention detention, it has to ensure that
Yes.
the copy was reached to him and
Yes, your lordship. And in Prabir Prukastia, your lordship, it has been held that it should be in writing. But in Bihan, it has been further clarified that Article 22 of Constitution of India, it doesn't prescribe that it should be given in writing. It may be communicated orally also.
Well,
Your lordship, I will come to that, your lordship. This is the Bihan, your lordship, 2025 SCR. Para 21, your lordship, I will come directly, para 21. Here, your lordship, I would like to put out, your lordship, here also division bench, my lord. And the earlier, the judgment which I have relied of the Honorable Supreme Court, only division bench. Same strength, my lord. And in that case was specifically deal with the NDPS. Here, your lordship, it deal with Article 22(1), wherein the main offenses were under 420, 467, 468, 471, read with 120 of the CRPC, not the NDPS. Now, your lordship will kindly come to para 21. Therefore, we conclude the requirement of informing a person arrest or the ground of arrest is mandatory requirement of Article 22(1). The information of the ground of arrest must be provided to the arrest person in such a manner that sufficient knowledge of basic fact constitute the ground is imparted and communicated to the arrested person effectively in language which he understands. The mode and method of communication must be as such the object of constitutional safeguard is achieved. Here it doesn't say, Your Lordship, in writing. Comes to the specific paragraph. Your Lordship, will come to para 13, my lord. Para 13 of Bihan. Here, Your Lordship, it says not required to be in writing, Your Lordship. Para 13, Your Lordship, then second paragraph, therefore, Your Lordship, next page. Page number 442, my lord.
Yes.
442. Therefore, as far as Article 22(1) is concerned, compliance can be made by communicating sufficient knowledge of the basic fact constituting the ground of arrest to the person.
13.
Para, my lord, 13, yes. 13, second para, Your Lordship. Initially, here the judgment of Lalubai Jogibai Patel
Yes,
has been
yes,
relied.
yes.
Then, Your Lordship, the therefore, after relying the judgment, it has held that. Therefore, as far as Article 22(1) is concerned, compliance can be made by communicating sufficient knowledge of the basic facts constituting the ground of arrest to the person arrested. The ground should be effectively and fully communicated to the arrestee in the manner in which he is fully understand the same. Therefore, it follows that the ground of arrest must be informed in a language which the arrestee understands. This is how, in case of Pankaj Bansal, this court held that the mode of conveying the ground of arrest must necessarily be meaningful so as to serve the intended purpose. However, under Article 22(1), there is no requirement of communicating the ground of arrest in writing. Article 22(1) also incorporates the right of every person arrested to consult an advocate of his choice and right to be defended by an advocate. If the ground of arrest are not communicated to the arrestee, as case may be, he will not be able to effectively exercise the right to consult the advocate. This requirement incorporated in Article 21(1) also ensure that ground for arresting the person without a warrant exists. Once a person is arrested, his right of liberty under 21 is curtailed. When such an important fundamental right is curtailed, it is necessary that the person concerned must understand on what ground he has been arrested. This is why the mode of conveying information on the ground must be meaningful so as to serve the object. Here also, Your Lordship, in writing is also not required. It clearly says. And Your Lordship will find in the case diary, Your Lordship, the notice has been served on the 50 also, before body search. So they are well aware of the fact that, your lordship, why they are being arrested. It has been communicated in written also, your lordship, and orally also. And that if they are disputing that, that can be assailed during the trial, which has been held by the Honorable Supreme Court, your lordship. Because there will always be a presumption, and there are sufficient material to draw that presumption, your lordship, that it has been duly communicated. And so far as our High Court judgment is concerned, my lord, in that case, there was in fact no column of reason of arrest or ground of arrest was there in the arrest memo. That is the reason this Honorable Court was pleased to grant bail by relying the Bihan case. Your lordship is aware of the judgment, which has initially granted by the court number 1, now Justice Atta. In that case, your lordship, ground of arrest was not there in the arrest memo. Here, ground of arrest and reason of arrest is there. And if they are saying that ground of arrest was not communicated, then let them give the suggestion what should be the ground of arrest for the person from whom the contraband has been recovered, from whose car.
Yes. Your lordship, I would like to rely on the judgment passed by the coordinate. The case is similar, your lordship.
There, your lordship, ground of arrest and reason of arrest was not there in the arrest memo. It's totally different with this present case. Because I appear in that case, my lord.
It was in the same case, probably.
Yes. But not this case. My lord, in that 3 of the judgment, which has been passed by this court, on the same case wherein in memo of arrest, there was no any column of reason of arrest or ground of arrest, which is there in this case.
There was nothing.
No, nothing was there in the
Okay.
arrest memo.
Okay.
For the 3, even we cannot able to, your lordship, satisfy this honorable court regarding the compliance. But in this case, ground and reason of arrest is there. In that case, it was not there.
So here, because that is why, what is the, there is only one column, 30.
30, yes.
AIML.
Not only one, there are several, your lordship, ground has been given there, right?
Regions stroke grounds of arrest.
Yes, your lordship.
You lordship, meantime, I would like to rely para 47 of the judgment.
Whether, just a minute, whether this, leave K, the ground stated is in L, M, and N. Is a grounds or regions?
This one, your lordship. Your lordship, that is what, your lordship, I am submitting. In some cases, it will be considered as a reason only.
So that is, it sounds like a region.
Yes,
that is why.
in some cases, but in some other cases, like the present case, your lordship, here it's an NDPS case, my lord, under a special act. And your lordship, why I am stretching on K? Because this is one of the ground for, your lordship, rejecting the bail under section 37 of the NDPS Act. That if the court finds that while on bail, accused is likely to commit any offense, then he should not be grant bail. So now here it says, prevent accused from committing any further offense. He is found to be in possession of, your lordship, contraband substance. Here in the arrest memo, your lordship, the judgment which I have referred, it says that for which section he has been arrested, that has to be reflected. It's clearly reflected, Bandardua PS case number so and so, under section 121B of NDPS Act, read B section 3, subsection 5 of BNS. And there, down below, your lordship, the ground or region of arrest is clearly reflected that why he has been arrested.
Sir, this reason, your lordship, this reason apply to all the arrested position. Your lordship, ground is different. Ground has to be very specific. It has to be very personal. The role has to be indicated. Because, your lordship, at the time of arrest, I was traveling as a co-passenger, and recovery was not made from my possession. It was not from my conscious possession, your lordship.
What, according to you, should the ground should have been?
The ground should, your lordship, if my involvement is there, the particular involvement should have been mentioned in the ground of arrest. Your Lordship, this reason to prevent, those are the reason for arrest. This is a formal parameter. And it has been clearly explained in para 47, Your Lordship. Even our
Para 47 of
para 47 of Parvir Pukra Yasta.
Purkasta.
Yes, you just read. Yes, you have read it.
Page number 38.
Yes, yes.
Now coming to the aspect as to whether the ground of arrest were actually conveyed to the applicant in writing before he was remanded to the custody of the investigation officer. We have carefully perused the arrest memo and find that the same nowhere convey the ground on which the accused was being arrested. The arrest memo is simply a pro forma indicating the formal reason for which the accused person was being arrested. It may be reiterated at the course of repetition that there is a significant difference in the first reason for arrest and ground for arrest. The reason for arrest as indicated in the arrest memo are purely formal parameter, and that is to say, to prevent the accused person from committing any further offense. For proper investigation of the offense, to prevent the accused person from causing the evidence of the offense to disappear or tampering with such evidence in all men, to prevent the arrest person from making inducement, threat, or promise to any person acquainted with the fact of the case, so as to dissuade him from disclosing such fact to the court or to the investigation officer. This reason would commonly apply to any person arrested on charge of a crime, whereas the ground of arrest would be required to contain all such detail in the hand of the investigation officer, which necessitate the arrest of the accused person. Simultaneously, the ground of arrest informed in writing must convey to the arrested accused all basic facts on which he was being arrested, so as to provide him an opportunity of defending himself against custodial remand and to seek bail. Thus, the ground of arrest invariably be personal to the accused and cannot be
Okay. And your lordship may kindly, your lordship, take into consideration the strength of the bench. Be communicated in writing. In Bihan, it says it is not required. Prior to that, your lordship, AR 2000, same bench strength, it says it is subject matter to be considered during the trial. And this case,
Subject matter.
yes, your lordship, regarding the non-compliance of the section 52 and 57, because in NDPS Act, section 52, your lordship, speak about the ground of arrest has to be communicated as and when he is arrested, when the person exercise our power under section 41, 42, 43 of the NDPS. This section, your lordship, this judgment deal with the NDPS. Here, specifically, NDPS case has been dealt with. But in Purkasta and Bihan case, NDPS case was not dealt with, my lord. In Purkasta case, your lordship, preventive detention was dealt with. And in Bihan case, it's a general law under IPC 468, 420. In your lordship, the AIR 2000 S Supreme 3661, here your lordship, Superintendent of Narcotic Crime Branch, here your lordship, section 52, 57, and your lordship, the specific with the NDPS Act has been dealt with same strength bench. Your lordship, AIR 2000 Supreme Court, your lordship. And your lordship, one more judgment to that your lordship extend, because your lordship, recently, your lordship, one more judgment is yet to come because it has been reserved, where it has been, your lordship, there was a discussion in the court, your lordship, whether in NDPS case, a person is found to be in possession of a 1 quintal of gunny bag, where police are expected to go back to police station and come with a ground of arrest. It's all depend on fact and circumstances of the case. Here they were intercepted, my lord. It is not a case that it was a chance recovery or something. There, your lordship, perhaps strong ground has to be laid, written there, your lordship, communicate then. But here, they were intercepted. Their body search was done in accordance with section 50. And then, your lordship, when their car has been, search has been made in their car, that particular, your lordship, contraband substance has been recovered, which they have admitted in their 180 statement, and section 50 has duly complied with. And the judgment which I have referred, your lordship, that clearly they discuss about the NDPS only. And Bihan case discuss with the other, no doubt, it discuss about the Constitution of India also, no doubt, your lordship. But it has to be considered by the fact and circumstances of each case. They cannot say that it is a general reason. Definitely, your lordship, if somebody has been arrested in NDPS case, as I've indicated, in section 37, your lordship, for rejecting the bail, this is one of the important ground to prevent the person from committing further offense. So why this cannot be a ground of arrest in NDPS? May not be in the IPC, in the general law, but why not in the NDPS case? That much, man.
Your Lordship, last judgment I would like to rely Sabir Chaudhary. Your Lordship, this judgment was passed by the principal bench, wherein, Your Lordship, it emphasized the importance of writing down the reason of arrest, relying the judgment passed by Pukan, Your Lordship. Purik, Your Lordship. And Your Lordship, the accused, Your Lordship.
This was also in NDPS case?
NDPS case, Your Lordship. Similar case, Your Lordship.
Ground was not given.
Your ground was not given. And Your Lordship, accused has a privilege to be presumed innocent, Your Lordship. Here, Your Lordship, section 37 of the NDPS Act says that offense to be cognizable and non-bailable. When the public prosecution oppose the bail application, the court satisfies that there is a reasonable ground for believing that he is not guilty of an offense and that he is not likely to commit offense while on a bail. Your Lordship, here, Your Lordship, if we take the consideration of section 37, accused person, the arrest memo does not disclose that it was not communicated. So, Your Lordship, there is a presumption that the accused person may not have been verbally communicated the ground of his arrest, as well as, Your Lordship, and the accused person, Your Lordship, it was not recovered from, contraband was not recovered from his possession. Therefore, Your Lordship, the benefit, Your Lordship, should be given to the accused person, Your Lordship.
On possession, Your Lordship, I will rely one judgment, Your Lordship. Then I will conclude, Your Lordship. Since my brother is again on his argument merit, so this one, not that one, Your Lordship, this one. On possession, whether possession, if non-recovery of the contraband from the possession of the person, be entitled him to be granted. Your Lordship may kindly come to, this is reported in 2021 10 SCC, page 100, Your Lordship, page, para 27, 28 and 29. Lordship, from 26. 26.
Yes.
Para 26, yes. What amount of conscious possession was also considered in Dharampal Singh versus State of Punjab, where it was held that the knowledge of possession of contraband has to be gleaned from the fact and circumstances of a case. The standard of conscious possession would be different in case of a public transport vehicle with several persons as opposed to a private vehicle with a few persons known to be one another. In Mohanlal versus State of Rajasthan, this court also observed that a term possession could mean physical possession with animus, custody over the provided substance with animus, exercise of dominion and control as a result of concealment, or personal knowledge as to the existence of the contraband and intention based on this knowledge. We have referred to the above precedent to reiterate the governing principle. At this stage of the proceeding, it needs only to clarify that the trial is to take place this court where evidence will be adduced. As regard the finding of the High Court regarding absence of recovery of the contraband from the possession of the respondent, we note that in India versus Ratan Malik, a two-judge bench of this court cancelled the bail of an accused and reversed the finding of the High Court, which has held that as the contraband heroin was recovered from a specifically made cavity above the cabin of a truck, no contraband was found in the possession of the accused. The court observed that merely making a finding on possession of the contraband did not fulfill the parameter of section 37(1)(b), and there are non-application of mine by the High Court. In line with the decision of this court in Ratan Malik, we are of the view that a finding of the absence of possession of the contraband of the person of a respondent by the High Court in the impugned order does not absolve its level of scrutiny required under section 37(1)(b)(2) of the NDPS Act. Here, Your Lordship, it clearly shows that merely because it was not in the possession, he cannot say that entitled to bail. He has to show something more, that he was not in the conscious possession. The possession means what, Your Lordship? It's the knowledge coupled with the mental element, Your Lordship. Here, Your Lordship, they have clearly admitted in the 180 statement that why they came to Bandardua, Your Lordship. And how many times, Your Lordship? One of the accusers clearly stated how many times he came here, on what occasion he has been arrested. So far as possession is concerned, Your Lordship, there is no merit in this case, Your Lordship.
Your Lordship, the accused person, they are in the custody for more than 58 days, Your Lordship.
More than
58 days, today 58 days.
how many days?
58. 58, yes.
Okay.
And the limitation period is 60, Your Lordship.
Okay, I'll pass order.
Yes, Your Lordship. Obliged, sir.
Offline.
This will be disposed, huh? Disposed, huh? Chamber. Yes, that NDPS also. Okay. Well, it's all same, 12, 13, same. 12, 13, same.
12, co-accused.
My lord, on last occasion, this honorable court has directed to me to take press step against the respondent. My lord.
You're taking steps.
Yes, sir.
Hard miss.
But he
How
said
many respondents are there?
only one.
Okay, hard miss. Miss?
He said
He?
SETH.
Your name is there
Yes, Your Honor.
in the cause list. Your name is there.
Yes, my lord.
Where do I find your name? Bengyarun, Tanatoni, Nabam Ramachera. Your name is there in the cause list? No.
I'm associate of the Mr. B. Arun.
Can counsel for the petition. Stop. The office note dated 9/6, not 9/6, 6/6/25 reflect that the not upon the respondent return which a postal note refused within inverted comma refused RTS. Stop. In the earlier occasion also it was under the settled principle of law, refusal to accept notice amounts to valid service. Accordingly, this court is satisfied. that the notice has duly been served with. No one appears on behalf of the respondent, Mustafa. Leaves this matter for admission after 3 weeks. Okay. Yes.
Ma'am,
Yes.
Madam, office note dated 6/6/2025 indicates that I have not filed an affidavit to bring on record completion of service by Justin.
Okay.
There's a reason why. Because the appeal was admitted on 27/1/2025. Thereafter, the notice was served, notice was furnished to me from the registry member. And I made every possible endeavor to serve notice upon the respondent, but she was nowhere to be found in the village. Thereafter, I even tried to serve notice upon her, but they refused to accept the notice. This fact was brought to the knowledge of this honorable court. And this honorable court, by order dated 25/3/2025, has stayed the execution proceeding.
You're for a petition?
Yes, madam, I'm for the petitioner. Now, it is for such reason that I could not file the affidavit to bring on record completion of service by Dusty.
Now, whether you will file compliance affidavit or cannot.
In the interest of justice, my lord, I may be allowed to take steps on the counsel for the respondent in the execution proceeding.
Okay. So this time, you could not locate or you could not serve
I could not serve
because the respondent changes addresses.
change her address, and even her relatives are refusing to accept the notice.
Okay. Mr. R.D. Tonga, Lana Council for the appearance, Mr. Person to the order of this court. He tried to pose service upon the respondent by a dusty service. However, we could not cause notice upon the respondent as the respondent kept on changing his address, and his relatives
also refused to accept
the notice on his behalf. Okay. Therefore, he prays that step by
through her counsel, my lord.
Okay. Okay. Stop. He further submits that is counsel in what case?
In the execution proceeding.
Okay. The respondent is being represented by his counsel in the execution proceeding, and therefore pray for allowing him to take steps upon the respondent through his counsel who is appearing in the execution case. Okay. So the prayer is allowed. So to this to learned counsel throw Dusty or what?
Dusty.
Okay, start. The prayer is allowed. The appellant shall take steps upon the respondent through his counsel by way of Dusty and file affidavit to that effect. Okay.
And my lord, I will furnish
file
the details
compliance
of
affidavit.
and I will furnish the details of the counsel. I will furnish the details of the
Okay.
counsel to the registry.
Okay. In the meantime, the appellant, the counsel for the appellant shall also furnish the details of the advocates for the appellant, or the respondent. Okay, the steps within 2 weeks.
A week.
1 week. 1 week. Steps by the in 1 week.
Look, there's another.
Let this matter be listed after 4 weeks.
4 weeks.
Okay.
But there's one IA.
What is IA?
IA is for stay of the impugned judgment which has been put to challenge in the main appeal. But however, in view of the order dated 25. 25, 3/2025. This I may be closed. This, because this honorable court has stayed the execution procedure.
Already stayed
Madam.
in Maine.
Madam.
Okay. When it was,
25/3/2025 in the main appeal court.
okay. In view of the order passed on
3/2025.
comma, this higher stands closed.
Okay. Well, there's an interim order that has been-
Okay, in the main then, in the last, in the meantime, the interim order passed earlier shall continue till the next date of this stay. The higher disposal. Okay. This is after 4 weeks. This was 15, this is 16. Okay.
May I proceed?
Yes, Your Lordship, I'm appearing for the private respondent in this matter, Your Lordship. I was supposed to file my affidavit in opposition. However, due to some personal difficulties, I could not file. So, Your Lordship, I'm praying for 1 week time to file my affidavit in opposition. What time can we
My
file?
lord, we have a small request if it can be considered, my lord. If my lord will see the prayer, my lord, in our prayer petition, our prayer is that there is an execution application that is pending before the respondent number 1. It may be decided early. That is our only
Respondent number 1.
the DC,
Okay.
Deputy Commissioner Alo, my lord. So our only prayer is that he may dispose of the.
You're decree holder. You're for decree.
I'm the decree. There was a cover decision, my lord.
Not exactly the decree holder.
There was a cover decision. So now,
Cover decision, okay.
yes. So now we have filed an execution petition asking that the cover decision may be enforced. Now that is the only issue. And in their reply, the respondent number 1.
They have not yet filed.
They filed. And
One has, but you are for respondent number 2.
the private respondent.
Private, okay.
So now in their affidavit in opposition, the respondent number 1, they have stated that the application is pending before them, but due to the election and other administrative issues, they could not dispose it. So now our only prayer is that this execution petition may be disposed of. Now, as the respondent number 1, the state respondent have admitted that it is pending before them. So, my lord, we are only seeking that this may be an order may be passed that this execution petition may be disposed of on merit as early as possible.
Your prayer, what is your basic prayer here? In the
Prayer is page number 10, my lord. Page number 10 of our petition, if I may read, my lord.
Just a minute. What otherwise the case is about?
The facts, my lord.
Okay, this is regarding marital discord.
Yes, my lord. So basically, my lord, there was an agreement, cover decision, and we have.
So in the marital case, what is to be executed?
Actually, my lord, in the cover decision, there were 3 points. Regarding the divorce.
There were 3
points, my lord. 3 decisions were made. First, regarding the divorce. Second was that the respondent number 2 will be allowed to take her belongings from my house, the petitioner's house. And the third one was that the respondent number 2 will transfer the land that she presently hold to me. She will return back the land to me. So in this regard, I had filed an execution petition for enforcement of the cover decision, my lord. So basically, my lord, it is before the respondent authority. Now our only limited prayer is that we disposed of.
Lordship, just 2 week time in transfer. Lordship, as my brother has already submitted that in decision number 2, I was allowed respondent number 2. Private respondent. Just a week time. Let him file.
My lord, our submission is that even if they file, my lord, we are not arguing on the merits. Our only contention, our limited prayer.
He is seeking only 1 week time. Yes, let us take up after 1 week.
1 week. My lord, our prayer was that even if they file a reply, they will bring on records facts. But our application is confined to direction to the respondent number 1 that the appeal that is pending before them may be disposed of. Our limit prayer is that. Now, before the executing court also, they can raise their grievance because they have not challenged the Kaba decision before any authority, my lord, and it has attained finality.
Now you see, so how you are agree by this?
Your Lordship, as my brother is already submitted, that in Kaba decision number 2, that I was allowed to take, get back the traditional or ornaments from the house of the petitioner. But this petitioner has
the execution petition.
Yes.
Is,
I have filed my representation, Your Lord.
before the execution court.
It is before the learned.
Yes, Your Lord.
Where have you filed your representation?
Before the deputy commissioner itself.
In execution case.
No, Your Lordship, prior to that, Your Lord. Before the filing of this
prior to
execution
that-
petition.
No, this has come to the stage of execution.
Yes, my lord.
That's what is the
Since
what?
the petitioner himself has not complied with the Kaba decision, Your Lord.
Now,
That
lordship,
things I will bring and record, Your Lord.
now that is a
No,
question
no.
to be
This is the execution case is pending for execution of the Keba decision.
before deputy commissioner Alo, my lord. So now what we are saying is that, my lord,
Now,
they-
execution, if he has filed for execution, probably then agreement or the settlement is for both. I think both are advantage position in the, as per the Kaba settlement.
yes, my lord.
Something is to be given to you, something is to be, okay, execution is for both, it appears.
Yes, my lord. So now,
Then it is applicable to him as well. Have you filed anything in the execution case? Objection, anything?
Your Lordship, I'm extremely sorry. I don't have the brief also, Your Lordship. Actually, my senior was supposed to.
Then why you are, why?
Your Lordship, I'm just submitting that. I have
No,
instruction to file.
always come with a brief, always come with a brief, huh? Court may require, answer to certain queries
Yes, Your Lordship.
in order to pass even a one sentence order.
Actually, my senior was supposed to appear in this matter, but due to some personal difficulty, he has to leave.
Not come with a assumption and presumption that it will be
Yes,
adjourned
sir.
easily.
Give me a-
At certain times, sometimes it happens that because of, see, it appears that so many orders was passed, it was filed earlier.
and my lord, the
This is
order has been pending for fifth
Okay,
execution.
Mr.
I want.
I bomb. Land Council for the respondent number 2, prays for further 1 week time to file objection.
Yes, sir.
Okay.
My lord, I have a small prayer if it can be considered, my lord.
Okay.
My lord, if they are seeking for 1 week's time, can it be fixed on Monday and taken up for hearing, my lord? Monday will be 1 week and it can be taken up for hearing, my lord, because the execution petition has been pending for nearly 5 years.
Let us fix it on Monday or Tuesday, any day.
Your Lordship, can it be on 23rd, Your Lordship?
My lord, they're seeking for 1 week and then
Yes, Your
23rd
Lordship,
will
I'll be
be
out of
not 1
session
week.
on Monday, Your Lordship, on some personal event. Can it be on 23rd, Your Lordship?
My lord, their reply is not necessary per se, my lord. We are only concerned regarding the stand of the government, my lord. That is respondent number 1, my lord.
Mr. G. Taro, Land Council for the petitioner has no objection, how, provided the date is fixed, okay? Miss, okay, her name, is also present on behalf of the respondent number 1 staff. As requested, let this matter be listed again on
23rd, Your Lordship. Kindly.
Your Honor, my lord, can it be on 16 or 17, my lord? 1 week will expire on 16 or 17.
I
my
will
lord.
be not
My lord,
available
on
in
one
this
hand, they are seeking for 1 week and then they are seeking for a date on
week.
23rd, my
Within this
lord.
week, Your Lordship, I will file.
My lord, that's why.
It may be
Then-
recorded.
then-
Within this week, I will file.
Let us keep it on 18, okay?
Your Lordship,
18.
I'll be
When
out
you
of
say?
station, Your Lordship.
When
My-
is it?
I'm
23?
preoccupied. Let it be on 23rd, Your Lord.
Okay, 23rd, okay.
Much
My lord,
appreciated.
Out of station, council. Consider someday you also
Yes, Your Lord, only matter of week. Your Lord.
seek consider.
My lord, then a small prayer that their affidavit, it may be filed within a week, even if the matter is taken up.
Okay.
I will file within
It
this week.
it is made it clear that in case the respondent number 2 failed to file objection is grateful prior to 23, no? The respondent shall file objection 1 day ahead of the next date is fixed above, and in the event of failure to the failing to file the objection on the said date, the case shall proceed on merit in accordance with, or based on proceed based on the In accordance with law, huh? Okay.
My lord, it may be fixed for hearing, my lord, on 23rd.
No, this is, okay. List it. Then the list on 23rd for admission hearing. Okay, yes, okay.
Much of it.
Yes.
Lordship, here in this case, service is completed.
No one appears.
WT notice, a message has been sent from police station Palin. However, it seems like
What
respondent
it says, what it says,
says that message has been received on 13/05 of 25.
the office note dated 28/5/2025 reflect that the WT message received from the OCPS Palin Pradari district stating that the notice upon the respondent number, how many respondents?
Your Honor, Lordship, there are 4 respondents.
All of them.
4, yes. 1, 2, 3, 4.
Is this message for all of them? All
Yes,
of them?
yes, yes.
Okay. That the notice upon the respondents have been served to the, okay. Notice have been served to the respondents, huh? Mr. Kambo, this is, the message says that through WhatsApp.
Pardon?
Notice was served through WhatsApp.
No. I took the steps by register post. Register post with AD.
But the message says that the notice and 3 others have been served to the mentioned name and address dated so and so through WhatsApp number so and so. This is the police has served notice to the opponent through WhatsApp, not practically handed over the notice.
Okay, I was not aware of it. Maybe
Have you seen? The WD message says so. This was the first notice. I think you have to serve. What is this case about otherwise?
this is a land dispute matter, Your Lordship. Land dispute matter.
I think they are
Challenging the mail order passed by village council.
Village council,
Yes,
decided
yes.
by village council.
Yes.
I think their presence is necessary. Then in that case, you may have to take press steps. It's by through WhatsApp. And then there is also only one telephone number, not to all. To the respondent through WhatsApp number 8119973192 stuff. In view of the above, Mr. Kambo, Learned Counsel for the petitioner, prays for allowing him to take press steps upon the respondent. Steps upon the respondent by a register post with AD, as well as by usual process. Within a week from today, and this matter again after 4 weeks. State
Lordship,
indicate.
I will serve by Dusty also.
Dusty also.
Yes, yes.
The Dusty service is also allowed. After closing.
After
After
3 weeks.
Dusty service upon the respondent, the petitioner shall file affidavit to that effect. Okay. The petitioner shall file compliance affidavit. Okay. Please dispatch after 4 weeks. Okay. Yes.
This application is for this setting aside of the interim compensation order passed by the judicial magistrate first one. The ground for this filing this application is
how many respondents are there?
2. One is state and another is private
2.
respondent is there.
You are it?
Yes.
Okay. Okay. State also.
Yes.
Then can it be
May-
listed
may I
for
proceed?
admission hearing? Since parties are okay.
Yes.
Mr. or Mr. David Tapa. Also or Mr. Tapo, you are correspondent number?
Number
Okay.
2.
Okay, Miss Jeannie. For state respondent and Mr. Tapo for P Tapo for respondent number 2. So since the parties, whether the record was called for?
It's not necessary.
Not necessary, okay. Since the parties are duly represented, let the matter be listed for admission hearing after 3 weeks.
Yes.
Okay.
All right.
Yes.
Yes, Lordship. Service has been completed, Lordship.
Yes.
Lordship, this is the Lordship
Yes. Is it-
crossing of the FI, Lordship, wherein it, POXO
Hello.
is also section
Just,
is also.
this is 19. This is 15. Okay. What is this matter about?
Lordship, this is regarding the crossing of the FIR. They have, yes,
Okay.
Lordship, for criminal.
Joint
cases.
petition or?
This is Lordship, not joint petition, on a merit, Lordship.
Okay.
Respondent number 2 is the
Section involved
victim.
is,
Lordship is 64, 96, 143 rape
what
and.
is this 64?
Lordship, because Lordship, this is trafficking, Lordship. This minor, this victim is minor, Lordship. That's why Lordship, POXO section 6 is also attracted.
This is POXO case.
Yes, Lordship.
Section
Lordship,
3 and
yes.
5 of the, okay, immoral traffic also. Oh, then this will be listed for hearing that.
Yes, Lord.
My lord, let the matter be disposed of.
We'll fix it next week then.
Yes.
Because in the order column, this is.
Then my lord, there
The
is a.
paper book is ready. Have you got the paper book? When did you receive? Are you ready otherwise? You are ready.
Yes, Your Lordship, but then I don't think that even the time will permit.
Then day after tomorrow.
Day after tomorrow.
My lord,
Or-
tomorrow then, madam.
Tomorrow,
after
tomorrow
tomorrow,
the
yeah.
list already prepared. So division methods are also there. It will be difficult. Day after tomorrow, can it be?
All right, day after tomorrow.
Just a minute, just let us see. This passed by which court? FIR when?
Yeah, session
no.
court, 0.
No, session code 0. Okay. Because in many of the trial courts, I'm on board, so that's
Oh,
why.
yes.
In
Yeah.
somewhere,
Yeah, you lost it.
even the advocate could not, because charge was framed by somebody, so that way, in any case.
In this
some
matter,
cases,
your lordship
directly,
is not
indirectly it was involved, as a member secretary, as a session judge. So if it is not involved, it's 0 case, probably not involved. Yeah? So then we'll fix it on
Day after
Uh,
Day
tomorrow.
after tomorrow.
day after tomorrow is Wednesday.
Thursday, on Thursday in that case.
We'll fix it on Thursday then.
Thursday, Your Lordship.
So, my lord, actually, I was supposed to go back to 0
Okay,
tomorrow.
when can you come?
My lord, then it will take time. If long date is going to be fixed, IA may be disposed of, my lord. There is a application for suspension of the interim order.
Okay, no, we'll dispose of the entire matter.
Then day after
What
tomorrow,
we'll
please.
do is, because this is in order column, what we'll do is we'll record that the paper book has been duly received and then the matter is fixed for hearing. Okay,
Mr. Okay, Mr. S. Koyang, Land Council for the appellant. Also have Miss P. Jeannie, Land additional PP for the state, and Miss J. Doji for the legal aid council representing the private respondent number 2.
Yes.
Stuff, huh? The paper book is ready and received by the respondents. In view of the above, let this matter be listed for hearing on the date will be. The other tomorrow would be
11.
11. Okay. 11. Is it okay? 11. Okay.
11. All judgment.
Yes. So, who you were to substitute? Whom?
Lordship, his wife,
Whose wife?
respondent.
Respondent.
Yes,
This is
Lordship.
a criminal appeal.
Yes, Lordship.
In the criminal appeal, just a minute, whom you have implemented first? Respondent is who? Who is this respondent?
I'm for the respondent.
Okay. Who is respondent? Respondent is informant.
No, Lordship.
No, Lordship. Who?
Respondent.
Okay, who are you then?
Respondent is the person who issued check.
Who?
Respondent is the accused person, Lordship,
Yes, Lordship.
who has been acquitted in
No.
acquitted in trial court.
This is what? Criminal appeal?
Yes, Lordship.
You are challenging the order. Which
Yes.
order?
Order dated 23/04/2020.
23 for, okay, by that order, what order was passed against you?
Lordship, in that order, 3 criminal appeal was criminal case was dismissed, in which the accused was.
Okay, you are the complainant.
Yes, Lordship.
I thought you are accused.
No, Lordship.
So you are the accused who has been acquitted.
Yes.
Okay. So, but the accused expired.
Yes, Lordship. Expired.
Now the right still exists.
Yes, Lordship, because his wife is the legal heir of the
Okay.
respondent, so
Miss,
Yasmin Gao. On Yasmin Gao on behalf of M. Kato.
your name is not there.
No, Lordship.
Why Gao?
Yes, Lordship.
Why Gao? Land Council appearing on behalf of Mr. You are appearing on behalf of M. Kato. Miss, yeah, why?
Why Gao?
Gao submits that during the pendency of this criminal appeal, the respondent, the sole respondent expired on, you knows the date?
No, Lordship.
Expired. And therefore, she prays. However, the right believe that, therefore she prays for some time to implead and to file application for impleadment of the legal heir of the respondent in place of the sole respondent staff. The prayer is allowed. When can you file?
Lordship, we may be given 3 weeks to file.
List this matter after 3 weeks. Okay, after 3 weeks.
Yes, Lordship.
Okay, stop. Mr.
T Dodung, on behalf of K Tama.
Learned Counsel.
T Dodung, DODUNG. On behalf of K
Mr.
Tama.
Dodong appear on behalf of Mr. K. Tama. Okay.
Obliged.
Obliged.
Yes.
May Your Lordship, Mr. Pangi is engaged in code number 1, so kindly matter may be listed after 2 weeks.
My lord, I am appearing for the respondent in this case.
Okay.
My lord, what has happened in this case? There was a decision of KEBA in 2006,
Okay.
and the KEBA decided that the land in dispute should be divided in equal shares between the respondents and appellants in 50-50 equal share. Now, we were agreed because according to us, the entire land belongs to us. Then, my lord, we filed an objection before the Deputy Commissioner in 2006 itself. It remained pending. And after that, my lord, as your lordship is aware, 2021, the new act of Arunachal Pradesh Civil Courts Act came into force.
Yes.
And by virtue of section 15, my lord, the entire matter was referred by the Deputy Commissioner to the district judge. And then the district judge sent the matter to the civil judge senior division. Civil judge senior division, my lord, decided the matter on 5/6/2023, my lord.
Okay.
So civil judge decision, my lord, was that the matter should be our appeal was dismissed.
The KEBA decision was upheld.
Yes, my lord. Then we preferred an appeal before the district judge. Now, in the appeal, my lord, the present revision petitioner before lordship has taken a plea that under the provisions of section 15 of the 2021 Civil Court Act of Arunachal Pradesh, second appeal doesn't lie. Only first appeal is permitted, second appeal is not permitted under the law. And their objection of maintainability was decided during the pendency of the appeal on 7/10/2023, holding that it is maintainable. Then the matter was taken up on merit finally, and on 22nd of December 2023, the case was remanded, my lord, to the senior division for de novo trial. Against that, this revision petition has been filed by the petitioner, my lord. According to them, the appeal before the learned district judge was a second appeal, and in terms of provisions of section 15 of the 2021 Act, second appeal is not maintainable, and therefore this judgment and order passed by the district judge should be set aside.
Okay, the second appeal can be filed before the district. Okay. First
Well,
appeal, according to them, was before the civil judge senior division.
Yes. According to them, the original decision was by KEBA, and then the appeal before the civil judge senior division was the first appeal, and the appeal we filed before the district judge thereafter was the second appeal, and in terms of section 15 of the 2021 Act, second appeal is not maintainable. Our remedy was only to come before this honorable court in revision against the order passed by the civil judge senior division. That is their objection, my lord.
Anyway, but since the learned counsel for the petitioner is not in the court now.
My lord, I am just now told that Mr. Pangi, my learned brother, has just now finished his case in court number 1. He was arguing an election petition. And if his juniors can call him, we can fix a date according to his, my lord, convenience.
Convenient.
My lord.
When has he given date? When the matter can be fixed? We can
Well,
fix the matter.
2 weeks.
2 weeks. After 2 weeks. After 2 weeks, any date you give them. They are ready after 2 weeks, any date.
My lord. But there is some urgency in the matter because some constructions were undertaken on the land, and a huge amount was spent on some infrastructure. More the time goes, my lord, more is the difficulty, my lord.
So, but it was filed by them only.
It was filed by them, but then there is a
That is what
status.
no stay, huh?
There is a status quo order for which both
Status
the
quo
sides,
order.
because yes, they were trying to encroach upon the land. Then on our application, an IA was filed, and in the IA, my lord, it was directed that the parties should maintain status quo. So in view of that, my lord, further constructions of our infrastructure has been stopped. So in that view, the matter, my lord, there is some urgency in the matter. Can my learned friend accommodate on day after tomorrow or maybe Thursday? If my learned friend appearing on behalf of Mr. Panging
Yes.
can inform after consulting with his senior.
Or the most the next week or what?
Next week
Okay,
or
Lordship, next week.
Huh?
Next week, okay.
Next week, okay.
Then let it be on 16th, my lord. Monday, 16th. If my learned friend appearing for on behalf of Mr. Panging agrees, let it be on 16th, my lord. Huh?
Okay, okay. 16, so many items it appears had already been fixed. Then, well,
Then let it be on 26th, my lord. 26th, my learned friend is convenient
26.
for my learned friend.
26.
Okay, Your
20.
Okay. Both the Islamic Council for the parties represented. On the request of both the Islamic Council for the parties. List is matter again on 26. Okay.
All right.
Much obliged.
All right. All right.